Hello, 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 and welcome everybody. Well, do I got news for you today? There's been a bunch of orders that have come in from the judge in the Bryan Kohberger case. And we also I've only read through the first two a little bit, just scanned through them. There's a bunch of motions here, you guys, or a bunch of orders here, you guys. We do get a little bit more information on some of the evidence, right, that they have been having under seal. I feel like there's going to be also some other things. We went through a couple things that have been unsealed, but I do believe that there is going to be more documents that are unsealed now that the judge has made these orders. So let me get this up on the screen to start this off. We're going to start with the first one. Good morning, Shannon's Copper from the West Coast. Good morning, Dawn. Hope everyone is having a great morning so far. So there's a couple of these, you guys, that are going to be really lengthy. So we may just scan through some of it, especially the beginning of some of these orders that the judge has made. It's repetitive, where he just explains the case, which we all know. So we'll read it the first time, but in the following motions where that piece is repeated, we're just going to skip over it. Because like I said, some of these, there's 5 of them, 5 orders that the judge has made, and 3 of them are really, really lengthy. But we get some tidbits in there, right? Good morning, Nana. So if you've not subscribed, please subscribe. Hit that notification bell on your way in. And only if you can afford it, please help out the channel. It helps me to be able to bring these things to you and put this time aside to do this for you guys. My hands are still very sore. You guys have seen on my community tab. We got buried in snow, and we got more coming Friday. So hopefully this doesn't take very long to get through, because I've got to get out there and get that snowmobile back in tip-top shape and get things tweaked on it, because I had a little bit of problems with it. So far, so good. Good. Okay, so we're going to start with this first one, you guys. If I do go too quickly for you guys, don't worry. Once we are done with this live, you guys can go back and scroll and pause type thing if there's parts that you feel I may have gone too quickly through, or I may have missed. So like I said, if you can, super chats are very much appreciated. This does take a lot of time. So with that, let's get going. So the first one is order sealing the exhibits to state's rebuttal to defendant's supplemental response to request for discovery regarding an expert witness. Based upon the state's motion to seal exhibits to state's rebuttal to the defendant's supplemental response to request for discovery regarding the expert witness filed herein and no objection from the defense, the court does hereby confirm an order that all exhibits attached to the state's rebuttal to the defendant's supplemental response to discovery for discovery regarding expert witnesses, oh my gosh, are exempt from disclosure and sealed pursuant to Idaho Court Administrative Rule 32G1 and I2E for reasons stated in the said motion. Thank you, Nana. Thank you, thank you, thank you. It does. It's free to do. So even if you can't afford the super chats, give the video a like, share it out, subscribe. It all helps. So this one was fairly quick, you guys. So let's go to the next order. Which one do I want to do next? This one here. So this one, oh no, let's not do that one. Let's do this one. Hang on. Let me share this differently, you guys, so I can just click up top. Hang on. I'm going to share my window so that way I don't gotta worry about clicking on a certain order. Anyway, you got to see it. It's behind the scenes stuff, you guys. There's different ways that we can share stuff. This way seems to be the easiest. I haven't even had my morning coffee, you guys. I'm drinking it as we're doing this. So, okay. So, order on the defendant's motions to suppress the arrest warrants, Pennsylvania warrants, apartment warrants. That's Bryan Kohberger's apartment in Idaho, an Idaho warrant to search person. We know that they fought hard, the defense, to get these arrest warrants and search warrants and everything thrown out, because if they could have done that, then the thing that would have fell into place was the fruit of the poisonous tree, which means that if the judge doesn't allow these warrants, then anything they gained from those warrants are the fruit of the poisonous tree and would not be allowed into evidence. So these ones were critical for the state. Okay, so let's go through this. This one, you guys, is 11 pages. Let's go through it. Defendant is charged with 1 count of burglary, and this is what I mean in these next orders that are coming up. A lot of this is going to be repetitive, so we will just skip through the introductions on the next one, so I'm not wasting your time. But I will go slow enough that if you do want to read through it all again, that you can on the replay. So, defendant is charged with 1 count of burglary and 4 counts of murder in the first degree in connection with the stabbing deaths of 4 University of Idaho students in the early morning hours of November 13th, 2022. On December 30th, 2022, he was arrested pursuant to a warrant at his parents' home in Pennsylvania. At the time of his arrest, Pennsylvania authorities executed search warrants for the defendant's person, his vehicle, and his parents' home. Around the same time, a 5th warrant for a search of the defendant's Pullman, Washington apartment was issued by a Washington magistrate. After the defendant was transported back to Idaho, law enforcement obtained a 6th search warrant for a search of the defendant's person. Okay, so different jurisdictions, because we know he took off, he went to Pennsylvania to his parents. Each jurisdiction needs their own warrants, right? When you get arrested, they are entitled to search you for weapons and stuff like that, things that you may have on you, but each jurisdiction is going to need their own warrant. So that's what they've done here, okay? Through 6 different motions, and we've got a little 1 here. So we got to watch for these things, you guys, because sometimes in these bottom parts, we will get more information as to why either the prosecution or defense is trying to keep things sealed. Sometimes we have extra information that we can gain through these, and stuff like that. And in here, we do get some more information, maybe in from the documents that had been sealed, right? But it's come out in these orders. So that's why it's important to go through them all and see what we can get that's new, right? So this, through 6 different motions, this little one here, it's down here. It says motion to suppress Pennsylvania search warrant for 119 Lambsden Drive, Albert Wrightsville, Pennsylvania, and statements made November 14th, 2024. Huh? This is interesting because this is almost November 14th, 2024. That's like 2 years after this incident. So what was these statements that were made 2 years later, almost to the day of the incident? Motion to suppress arrest warrant. So did his parents, like here where it says November 14th, 2024, did his parents maybe say something? His sisters? Because there were statements made that they're trying to suppress, right? Motion to suppress arrest warrant. Arrest warrant November 14th, 2024. This doesn't make any sense. What is this arrest warrant from November 14th, 2024? Because this happened in 2022. So, this is interesting. Was it around November 2024, you guys, that he was moved from Moscow to Ada County? Was there statements that were made? I don't know. What is this arrest warrant from November 14th, 2024? Motion to suppress regarding a Pennsylvania search warrant for white Hyundai Elantra bearing the VIN number. They give us VIN number, November 14th, 2024. Or were these motions that were made on November 14th, 2024? That's what I'm kind of thinking now, that these are probably motions that were filed back in November 14th, 2024. A motion to suppress Pennsylvania search warrant for Mr. Kohberger's person, November 14th, 2024. Yeah, these are motions that were made on that day for the initial warrants. Okay. Motion to suppress warrant search for Mr. Kohberger's person, and motion to suppress regarding the search warrant for defendant's apartment, November 14th. Okay. Insofar, the defendant argues the 6 warrants at issue are invalid under a Franks versus Delaware. And we're going to get into that too, because they had made a motion for a Franks hearing. We'll see what the judge decided on that one. Due to claims of recklessly and intentionally false or omitted material information, and or because they were based on law enforcement's allegedly unconstitutional use of the IGG, these arguments were addressed in the court's order on defendant's motion to suppress the IGG and order on defendant's motion for Franks hearing, entered contemporaneously here within. Defendant also argues the 6 warrants must be excised of any information obtained through prior illegal searches, referencing his other contemporaneously filed suppression motions. Right, fruit of the poisonous tree. However, the court did not find any prior searches to be illegal. Okay, so through these 6 different motions, right? Hi, Looby Loo. A defendant seeks suppression of evidence gathered by law enforcement through these warrants on several grounds. His arguments for each motion have largely been disposed of through the court's contemporaneously filed orders. Still remaining, however, is 1. whether suppression is warranted due to law enforcement's failure to knock and announce in executing warrants at the Kohbergers' residence, and 2, whether the defendant's post-arrest statements are suppressible as fruit of the poisonous tree and or due to Miranda violation. So they're trying to claim a Miranda violation now. And this knock and announce, that's regarding the search warrant that they had at his parents' home where they busted through the door, right? They busted the door, and apparently, from what I've read somewhere, now I've not been able to verify it, but I heard that a sliding glass door was also busted. Now, this knock and announce, I can see why they didn't use it, because they know that he has weapons, because they would have done a search on him prior to going in with this warrant, and they would have seen that he did have firearms. He'd already taken the life of 4 other people, allegedly. So they were not going to give him any heads up that they were coming in. Also, it kind of, hopefully stops whoever they're going in there for. In this instance, it was Bryan Kohberger, for getting rid of evidence, like flushing it, stuff like that, right? So that's why they didn't do a knock and announce. Sorry about that, you guys. If I got a cough, I'm going to mute myself. I'm just getting over a cold again. So the suppression hearing on the portion of the defendant's motion is at issue is this order 4 that was held January 24th. Okay, so there's a little 4 here. We're going to look to see what that is. Number 4 is evidence and argument on the Franks motion and IGG motions. The motion were heard on January 23rd. The balance of motions to suppress was taken up the following day. So that is all the arguments regarding Frank's motion and everything. We're going to get into it, you guys, because we're going to be, one of these orders that the judge made is regarding this. So we're going to get information on that hearing that was sealed from us, right? Oops, where was I now? Okay, so we were right here with the order number 4. Was held on January, during which time court received testimony from Detective Corporal Brett Payne and Detective Lawrence Mowry, both from the Moscow Police Department. The court found both detectives to be credible and reliable. Ha! So right now, you guys were reading the motion to suppress all the search warrants and arrest warrants and that. We're reading the order that the judge gave on that. The following argument, the court took the matter under advisement. The court finds suppression is not warranted because 1, exigent circumstances excused the abbreviated knock and announce, and 2, defendant has not established a Miranda violation. Okay, so the standard of review for a motion to suppress is verificated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court, with State versus Valdez Molina. A trial court's ruling on a motion to suppress evidence combines the issue of law and fact, and the trial court's factual findings will not be overturned unless they are clearly erroneous. I'm having problems speaking today, you guys. When a decision on a motion to suppress is challenged, the application of constitutional principles to the facts found will be freely reviewed. Hello, Crazy Graham, Shannon's Copper, Luby Lou, Amber Lee Jones. Hello, everybody coming in. Okay, so the findings of fact. On November 13th, 2022, an officer from the Moscow Police Department. Now, let's really pay attention to what the judge is saying here, you guys, because we could get some extra information here, okay? The Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Madison Mogan, Kayla Goncalves, Ethan Chapin, and Xana Kernudel. Each appear to have been stabbed to death. The investigation that ensued was a multi-agency affair involving members of the Moscow Police Department, the Idaho State Police, and the FBI, among others. The defendant, who was a PhD student at the Washington State University in Pullman, Washington, emerged as a suspect in the investigation. On or about December 16, 2022, defendant left his Pullman apartment and drove to his parents' home located at 119 Lambsden Drive in Albrightville, Pennsylvania, where he remained. On or about December 28, 2022, the FBI and Moscow Police Department requested assistance from Pennsylvania State Police, PSP for short, in their investigations, specifically in obtaining and executing warrants. Okay? As part of this assistance, the PSP reviewed reports and affidavits prepared by the Moscow Police Department, including a probable cause statement prepared by Detective Brett Payne outlining the circumstances of the crime and the investigation to date. Hello, K-Mitch. On December 29, 2022, a criminal complaint and probable cause order were filed in this action, and the Latah County Magistrate issued a warrant for the defendant's arrest. And we'll see all those footnotes at the bottom when we're done going through this. The same day, the PSP applied for and obtained 3 search warrants from a Pennsylvania magistrate, 1 for his parents' home, 2 for the defendant person, and 3 for the defendant's vehicle, which was believed to be parked in the garage of his parents' home. I'm just going to say parents' home because I don't want to have to keep repeating 119 Lambsden Drive. These search warrants were supported by the affidavit of probable cause by Trooper Justin Leary, to which was attached Detective Payne's probable cause affidavit statement. Defendant's Exhibit A to Lambsden motion. Later that day, PSP received the signed arrest warrant issued by the Latah County Magistrate. Late in the evening of December 29th, 2022, the PSP and its Special Emergency Response Team, CERT, prepared for the execution of the warrants. Okay, before we start with this here, let's read this. The court's findings are based on suppression hearing testimony provided by Detectives Payne and Mowry, as well as the following documentary evidence. Defendants Exhibits A and B in support of his motions to suppress regarding the Pennsylvania search warrant. Okay, so this is what they fought. These are the motions that were heard on January 24th, which we couldn't see. So they're saying prior to this point, investigators had been surveilling 119 Lambsden, which is his parents' home, and had observed the defendant walking near the residence in the early morning hours of December 27th, 2024. Detective Payne was present briefly to observe the final preparations, but then departed to prepare the defense for the defendant's arrival at the PSP police station. That's in Pennsylvania. It was Detective Payne's understanding that PSP and CERT were preparing for a knock and announce entry. During their final preparation, CERT snipers set an umbrella around the... Wow! So they had snipers and everything around his residence. They were not playing. So CERT snipers set an umbrella around the residence to monitor any activity therein. Well, a helicopter, they weren't playing, monitored from overhead in the event the defendant exited the residence. See State's Exhibit S5 to Lambsden ejection. Ooh. Hang on a sec, you guys. Sorry, like I said, I'm at the end of this cold. So we're getting some more information here. They had snipers all around that residence. They had a helicopter over above. Okay. The snipers observed a kitchen light turn on and saw a taller, young white male wearing a black hoodie standing near the sliding glass door leading out to the deck. At 12:40 a.m., the same person was seen again. So they were there for a bit watching that house. This time, officers were able to positively identify the person as the defendant. See also State's Exhibit S4 to Lambsden objection. So maybe there's a photo. Maybe they got photos because they had snipers all around that house. We're learning that for the first time right here. Whoa. At 12:55 a.m., the light turned on in the garage where the defendant's vehicle was believed to be parked. What was he doing going out to his car at 12:55 a.m., right? At 1:03 a.m., the lights flashed in the garage as if the vehicle was being locked or unlocked by a key fob. At 1:09 a.m., the defendant was seen in the kitchen of the home, this time wearing rubber gloves and handling a plastic baggie. Based on these observations, law enforcement believed the defendant was potentially destroying evidence from the vehicle that was related to the homicides. And we're going to have to look at this number 7. Law enforcement was also aware that the defendants possessed a Glock handgun, prompting a concern for over officer safety. Oh my gosh, will they get it together? Due to the defendant's heightened mental state of awareness or threat level of police possibly tracking him. See State's Exhibit S5 to Lambston objection. So this is all stuff that was held in that hearing that we didn't get to hear, that we will be able to get to hear. Thus, law enforcement made the decision to shorten the knock and announce when executing the warrants. So something changed. It was supposed to be a knock and announce, but something changed when they seen this going on. He's dressed in black with a black hoodie. He's got gloves on now. They know he's got a Glock. He's going back and forth to his, out to his car, back in, looking outside. He's, his mental state isn't very good at this time, they felt, okay? So at approximately 1:14 a.m., CERT made announcements from a Bearcat parked in the driveway of the residence. Immediately following announcements, CERT effectuated a forced entry into the residence. The defendant was arrested without incident in a bedroom. His vehicle was located and secured in the garage. Once apprehended, the defendant was handcuffed and placed in a police vehicle. Okay, so here's 7. And they have an exhibit to this too, right? Okay, so 7 says, up here we see number 7. Okay, there's a footnote up here. So we're going to check that out. As set forth in Detective Payne's probable cause statement accompanying the search warrant affidavit for the 3 Pennsylvania warrants, it was believed defendant drove his vehicle to 112 King Road, committed the homicides, then fled in his vehicle, see Defense Exhibit A to Lambston motion. Thus, when law enforcement was preparing to execute the Pennsylvania warrants, they were aware there were potentially evidence of the crime still inside the vehicle. And then they've got another one up here at 1:14 a.m. CERT made announcements from a Bearcat, and they got this number 8 footnote. That footnote says a Bearcat is an armored vehicle used in SWAT operations. So he was notified that he was in a police vehicle and being audio and video recorded, which he acknowledged. While awaiting transport, the defendant informed law enforcement that he had an unloaded Glock 22 handgun in the residence by his bed. Okay. Why would he have unloaded Glock 22? I was going to say, if it was loaded, I would have said, okay, he was waiting. And if they came in, he was just going to shoot himself, right? But it was unloaded. Okay. During transport, the defendant engaged in small talk. Oh, okay. So here's the statements that they're saying he made. Defendant engaged in small talk with the accompanying officers. When the defendant expressed at one point that he wanted to know what was going on with his arrest, law enforcement told him investigators were going to speak to him at the station about the situation. The details of the investigation were not discussed with the defendant. Once they arrived at the station, the defendant was escorted into the processing room to await the interview with Detective Payne, which occurred 10 minutes later. The defendant was then informed of his Miranda rights, and an interview subsequently began. Okay. Conclusions of law. There are 2 issues before the court. 1, so these are the issues that the defense has brought up, right? 1, whether law enforcement failed to comply with the knock and announce rule in executing the warrants at his parents' home. Well, from what we just read, when they now know that he has a gun, he's got gloves on, what is he planning to do? He's going back into his car, he's going into the house, he's got a black hoodie on, and now he's got these gloves on, right? That gives them concern for officer safety. So they made the call to forget the knock and announce, although they did, announce from the Bearcat in their yard, which further tells me that they were worried about officer safety. They bring in the Bearcat so they have something between them and the suspect. They've got some sort of safety net there where they can be protected from any gunfire or anything like that that may happen, right? We're not saying it did. We're saying that may happen. And number two, whether the defendant's post-arrest statements are suppressible as fruit of the poisonous tree and or due to a Miranda violation. Well, the cop just said that they just nonchalantly talked. They didn't discuss anything about his charges or anything like that. And he was given his Miranda rights before any questions were asked of him. So he was not questioned in any way. So before the officers can talk to him, they have to give the Miranda rights, which they did. The statement contends law enforcement abbreviated knock and announce was justified by exigent circumstances, and further defendant statements are not suppressible since there is no poisonous tree, and because he has not demonstrated any incriminating statements were made while under interrogation. The state is correct. Boom. So A, law enforcement did not violate the defendant's rights in executing the Pennsylvania warrants. So applicable law. Speak properly. Please forgive me if I mess up some words today. I am still recovering. Okay. Applicable law. Defendant contends that law enforcement's failure to fully comply with the knock and announce rule in executing the Pennsylvania warrants violated his rights under the Pennsylvania and or Idaho constitutions. And they state number 9. Let's read that since we can see it at the bottom here. The 9 footnote says defendant is not asserting his Fourth Amendment rights were violated. Though not cited by either party, this is likely because the United States Supreme Court has held that a violation of the Fourth Amendment knock and announce requirement does not require suppression of evidence. Okay. Let's continue. While he contends Idaho law should be applied to law enforcement's actions under a conflicts of law analysis, he recognizes at the same time that there is very little daylight between Idaho and Pennsylvania law on the issue. Well, Idaho law doesn't apply in Pennsylvania. Okay? Likewise, the state notes there are little substantive, oh my gosh, this is going to be a long day, difference between the two knock and announce, and therefore does not take a position on what law should apply. The court finds it unnecessary to choose which law should apply given their virtual identicality. Okay, hang on a second, guys. Let's get some heat on my back here. Okay. Let's continue. Idaho's knock and announce statutes require police to announce their presence, purpose, and authority before entering someone's house. And I'm not going to read all these IC 1940. You can see it. These requirements are also imposed by Article 1 of the Idaho Constitution. State versus Ranch 99, Idaho. In Ranch, however, the Idaho Supreme Court adopted an exception to the rule for under certain circumstances. Okay. While the court cautioned that such exigencies are to be determined on a case-by-case basis, it did set forth general oh my gosh, what is wrong today? Circumstances under which exigent circumstances may be found, including 1A, reasonable belief that a compliance with a knock and announce statute would result in the destruction of evidence. That's what we talked about earlier. Hello, Sybil, your favorite family. Long time no see. Welcome. Good to see you. Number 2, or a reasonable belief that compliance would place the officer in peril. In addition, the court set forth 6 factors to consider when determining whether exigent circumstances exist. The gravity or violent nature of the offense with which the suspect is to be charged, whether the suspect is reasonably believed to be armed, a clear showing of probable cause, a strong reason to believe the suspect is in premises to be entered, and 5, the likelihood that the suspect will escape if not swiftly apprehended, and 6, the peaceful circumstances of the entry. I don't know if I should have attempted this today, you guys. Between being in pain from top to bottom and having this end of this cold, it's going to be a long day. So please bear with me. I'm doing my best. Sybil saying hi to everybody. Yes, it's been a long time since we have seen Sybil, but it is good to see you guys, as well as Crazy Garam has now come in too. Hello, everybody, and welcome. Okay, so the FERT explained. Okay, the court further explained the exigent circumstances could include these immediate circumstances where a defendant may be armed, where evidence may be easily and immediately destroyed, where a defendant may escape, or where a defendant has engaged in furtive conduct. Once it is determined a defendant's rights have been violated by police entry into a residence, suppression, get it together, of evidence resulting from the entry is required under Idaho's exclusionary rule. Pennsylvania's knock and announce rule is set forth in its criminal rules and is imposed under Article 1 of Pennsylvania's Constitution, prohibiting unreasonable searches. Okay, so let's just go through these quickly. So this one here, the officer may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the warrant if, after notice of his authority and purpose, he is refused admittance. Hello, Grunger. Hello, Grunger. Yes, me too. I think that they may want a plea deal after all of this. Hello, Shy. And welcome. Sybil. Oh, you're gonna get a comical one today because I don't know why words just are not coming out of my mouth properly. Anyway. Okay. So the second one, to make an arrest if the offense is a felony, which it was, a private person, if any public offense, a peace officer may break open the door or window of the house in which the person to be arrested is in, or which there is reasonable ground for believing him to be, after having demanded admittance and explained the purpose for which admittance is desired. Rule 207 is a law enforcement officer executing a warrant shall, before entry, give or make any reasonable effort to give notice of the officer's identity, authority, and propose to any occupant of the premises specified in the warrant unless exigent circumstances require the officer's immediate forcible entry. Okay, so Pennsylvania's Constitution prohibiting unreasonable searches and seizures, and they state this, Commonwealth versus Carlton. Pennsylvania courts recognize 4 exigent circumstances justifying dispensing with the rule. 1, the occupants remain silent after repeated knocking and announcing. 2, the police are virtually certain that the occupants of the premises already know their purpose. 3, the police have reason to believe that an announcement prior to entry would imperil their safety, which they said they have. They did announce from the Bearcat. The police have reason to believe that evidence is about to be destroyed. He was wearing a hoodie and gloves, so they didn't know. And he had gone out of the house into the garage, into his car. They heard or seen the lights flashing. Don't forget, they had his parents' house surrounded with snipers, we've now found out. They had a helicopter in the air. His parents' house was surrounded with snipers who were watching his every move through their scopes, right? Okay, these circumstances are viewed under an objective standard, looking only to the facts and circumstances with which the officers are faced at the time they act on their decision to dispense with the knock and announce. As in Idaho, violation of Pennsylvania's knock and announce requirements result in suppression. As applied to the facts here, there are no substantive differences between the knock and announce standards under Idaho and Pennsylvania law. Consequently, the court need not determine what choice of law applies. Okay, so number 2 is it is undisputed that law enforcement executed an abbreviated knock and announce prior to entry into his parents' residence. According to the state, however, compliance was excused by exigent circumstances, namely law enforcement's belief defendant was destroying evidence of the crime and that compliance with knock and announce would have placed the officer's safety in jeopardy. Defendant argues these are not true exigencies. He notes that he was surveilled by law enforcement prior to the execution of the warrant. We do know that one of the snipers that had surrounded that house seen him putting on gloves or coming out of the garage with gloves, with a baggie, this and that. So they felt he was destroying evidence. They knew that he was armed because he was registered to have had these weapons, etc. So, yes. Let me see. Law enforcement's belief defendant was destroying evidence of the crime and that compliance with the knock and announce would have placed the officer's safety in jeopardy. The defendant argues these are not true exigencies. He notes that he was surveilled by law enforcement prior to the execution of the warrant and there was no evidence he was seen with weapons. Even though the defense says he wasn't seen with a weapon, but he was seen with baggies, and now, like they seen him in the kitchen, he didn't have these gloves on. Now he went to the car, he's got these black gloves on, he's coming out with baggies, black hoodie. He could be destroying the evidence, right? Hello, Chase. He's beyond toast, yes. Okay, so if you guys want to read through the footnotes, you can. We've already read this. If you haven't seen that, go back to the beginning where he was surrounded by snipers. That house was surrounded by snipers and a chopper in the air, as well as the SWAT team, CERT team, and all that was there. They're citing here, defendant cited no evidence of law enforcement's observation in this regard. The only evidence this court could locate is from the search warrant application for the Pennsylvania warrants, where the PSP trooper Larry states investigators began physical surveillance of the property and area of Bryan's parents' home in Chestnut Township, and in the early morning hours of Tuesday, December 27th, observed Bryan Kohberger walking near his residence. Exhibit A, page 9, 2 lambs in motion. In furtherance of his argument, the defendant cites to State versus Ramos, where the Idaho Court of Appeals held that executing officers believe that the home contained large amounts of marijuana was not alone sufficient to justify the officers breaking down the door 5 seconds after knocking and announcing. Such a rule, the court observed, would impermissibly create a blanket exception to the knock and announce rule, which Roush sought to avoid. The court further found that the officer's exposure in approaching the home did not justify a violation, observing that nearly all residential homes have exposed front aspects. So they're just citing cases here where the defense has used these prior cases and their outcomes to try and back their motion, right? The defendant also relied on this one, the Commonwealth versus Kitchener, where the officers knocked and announced heard running footsteps within the residence, and believed the man was trying to escape or harm himself. They forcibly entered the home. The court found that given everything the officers knew prior to executing the warrant, the forcible entry was justified. The defendant points out that unlike in the Kitchener case, law enforcement had no knowledge that the defendant had a prior criminal history, a reputation for violence, or was a gun aficionado. So they did not see him with a weapon, and therefore there was no reasonable basis to fear for their safety. At most, he argues law enforcement had nondescript fears, such as those presented in Ramos. There are two infirmities in the defendant's argument, however. First, he entirely ignores the destruction of evidence existency, which is what law enforcement relied upon greatly in dispensing with the knock and announce requirement here. The evidence demonstrates that while preparing to execute the warrants, law enforcement identified the defendant in the early morning hours as he turned on a light in the kitchen and then proceeded into the garage where his vehicle was believed to be parked. Law enforcement was aware that the defendant was suspect of having driven that vehicle during the commission of the homicides and knew that it could contain evidence. Law enforcement then saw vehicle lights flash in the garage as if a vehicle was being locked or unlocked or locked. Immediately afterwards, they saw the defendant again in the kitchen wearing rubber gloves and handling a plastic baggie. Further, it was 1:09 a.m. in the morning, a time when most people would not be removing items from their car with rubber gloves. That these observations gave rise to the reasonable belief that perhaps, aware of law enforcement surveillance, the defendant was destroying or secreting evidence of the crimes. Second, compounding the concern of potential destruction of evidence, there was an equally compelling concern that a knock and announce could pose serious danger to law enforcement. Law enforcement had reviewed the investigation reports and probable cause statements provided by Idaho detectives. The executing officers knew the defendant, based on compelling evidence, was believed to have orchestrated an unprovoked and exceptionally brutal quadruple homicide with a knife. They had informed he was in possession of a Glock handgun. They knew he was in the residence, potentially aware of law enforcement's presence and potentially destroying evidence or perhaps retrieving his gun or a weapon from the vehicle. His vehicle was in the garage nearby, thus giving him means of quick escape. While prior to allegedly killing 4 people, the defendant may not have had an extensive criminal history or general reputation for violence, as did the defendant in Kitchener, it does not mean law enforcement's safety concerns were unreasonable given what they knew. When these circumstances are collectively considered, the court finds that law enforcement was well justified in making an abbreviated announcement and forced entry. Thus, suppression is not warranted. Oh, it gets better, Shannon's Copper. Wait, this is just on the defense's motion to have the arrest warrants and everything suppressed or thrown out, right? Wait, we get into more. The defendant has not established he was interrogated when he made unidentified statements. So they didn't even list what statements Bryan Kohberger apparently made that they want suppressed because they said he wasn't read his Miranda rights. Well, they weren't questioning him yet. They don't got to read you your Miranda rights, until you're okay. Look we're just here to get you. We're bringing you back to the station. You have your Miranda rights. He knew. He had his PhD in law or was going for it, whatever. He knew not to talk. And he was read his Miranda rights long before he was questioned. Okay, so defendant next argues any statements he made to law enforcement prior to being Mirandaized must be suppressed, either as fruits of the poisonous tree or as a Miranda violation. Having determined the execution of the warrants at his parents' home were valid, the question is whether there was a Miranda violation. The court finds there was not. Amber Lee Jones, Shannon's Copper. Shannon's Copper says this boy is done. He's got no chance. Like I'm saying, you guys are saying this, okay, on just what we're able to read. There is so much more that we don't know yet as far as stuff like this goes, what was done, how it was done, what they seen, what they got. All of that has been under seal. So if there's people right now saying and can say this boy's done, can you imagine once everything comes out? Like that little window that I'm giving, that 10% chance that he could be innocent, because 90% I believe they got their guy. Um, and that's only my opinion. Everybody is entitled to their own, and I know a lot of people believe that he's innocent, and that's okay. Personally, I believe they've got the right guy. I'm leaving that 10%. I want to hear what the defense has to say, because everything they've given so far is a nothing burger. He was out driving around. He was at this park observing the stars. His GPS does not show him being anywhere near there. Out just driving around. He wasn't near the 1122 King Road. He's on video. They've got him. If you guys can see my thumbnail, I've got a picture of Bryan Kohberger sitting in that car that's on my thumbnail. I thought it was fitting. So, pursuant to the Miranda in its progeny to protect the Fifth Amendment privilege against compulsory self-incrimination, the police must inform the individuals of the right to remain silent and the right to counsel, either retained or appointed, before undertaking a custodial interrogation. Right. They didn't start interrogating him until they got him back to the station, and the detective from Moscow was there to interrogate him. That's when they got to read him his Miranda rights. Just putting him in the back of the cop car to transport him, they don't got to read him his Miranda rights yet. And it says right here, police must inform individuals of the right to remain silent and the right to counsel, either retained or appointed, before undertaking a custodial interrogation. Okay? The functional equivalent of interrogation includes any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response. Custody is determined by whether there is a formal arrest or restraint on freedom of movement of the degree associated with the formal arrest. The state does not dispute the defendant was in custody when first detained. However, there is no evidence before the court that the defendant was interrogated at any point from his arrest to the time he was formally interviewed by Detective Payne, at which point he was Mirandaized. The sole evidence is that the defendant engaged in small talk with officers, with the only exception being when he briefly asked about his arrest and was told that investigators were going to speak to him at the station about the situation. Voluntary or spontaneous statements or questions, unprompted by interrogation, fall outside the scope of Miranda. And that's why, your lawyer tells you, keep your mouth shut. Don't say a word. Because if the officers are not trying to prompt answers or ask questions, anything you say is going to be held against you. Now, if it's just small talk and you happen to, oh God, I should have done this and I should have done that. If you say that, that officer has not tried to ask you questions or prompt you to give any kind of answers or anything like that. So anything you say, you're not protected. That's why lawyers say, keep your mouth shut. Conclusion. Here we go, you guys. No constitutional rights have been violated as per this order. We've got 3 more orders to go through. Okay, based on the foregoing, the court denies the following. The defendant's motion to suppress the Pennsylvania search warrant for Bryan's parents' house. Defendant's motion to suppress the arrest warrant. Motion to suppress Pennsylvania search warrant for White Hyundai. Defendant's motion to suppress the Pennsylvania search warrant for Mr. Kohberger's person. Defendant's motion to suppress the search warrant for Mr. Kohberger's person again. So he was searched twice, once probably in Pennsylvania, once in Idaho. And the motion to suppress the search warrant for the defendant's apartment. These were all just signed late yesterday. You guys, I know Idaho's like 2 or 3 hours behind me because I'm on East Coast time. So I know they're 3 hours behind. And before I went, I had to go and pick up a few things at the grocery store. But before I left at 5 o'clock, I checked the record and this had not been filed yet. So somewhere between um, the time I went just to the grocery store for a few minutes and 7 p.m. Eastern, I was gone for a couple hours. This dropped and I didn't think to check it again. So this was probably dropped, I would say between 6 and 7 p.m. my time, Eastern. So I only checked again this morning, like I do every morning. I check the records, I do some card pulls, and yeah, lo and behold, here we go. So that's why I'm covering it now. Okay, so that was this one. Oh gosh, I'm not looking forward to the next ones. Okay, this one here is 36 pages. This one here, the motion for the Franks hearing is 38 pages. This one here is for the order on the defendant's motion to suppress the IGG, and it is 29 pages. Which one do you want to do first? I'm going to leave it up to you. Do you guys want the order regarding the defendant's motion to suppress the AT&T, Google, USB, Apple, and Amazon? We do know now, somebody slipped it out, you guys. I think it may be in this one here, that the Dickies were purchased at Walmart and the K-Bar and Sheath were purchased on Amazon. So which one do you want to hear first? Do you want to hear the motion to suppress the Google, AT&T, Apple, and Amazon? Do you want to hear the order on the Franks hearing, or do you want to hear the IGG order? Which one do you want to hear first? The one that gets the most votes? That's the one we're going to read next because these next three are pretty long. Let me do this. How about we do a poll? Um, okay, give me a second, you guys. I'm gonna put up a poll. Hang on. Okay, I'm gonna give it a couple minutes, you guys, for you guys to pick which one you want next. Please, if you have not smashed that like button, go on out and smash that like button. Come on back in. When you come back in, make sure you got live chat selected at the top of your screen. So as soon as we get the results, I'll give it 2 minutes. That gives me 2 minutes just to run and heat up my coffee. When I come back, it's not even going to take me 2 minutes, you guys. Whichever one is in the lead, that's the one we're going to do next. Give me 2 minutes. All right. So back. Didn't take long. And we are deadlocked. Okay, so there's the end of the poll. It's 50-50. Okay, I'm going to write down a number. Um, okay, we're going to ask how to pick. Yeah. I'm going to ask one person to pick a number. Don't do it yet. I'm going to ask this person to pick a number. Shannon's Copper, I'm going to ask you to pick a number. Hang on a sec. Let me just write down a number here. And the one that you are closest to. So we got a tie between the Franks. Okay, I'm going to give that a number. And I'm going to give the Google, etc. I'm going to give that a number. Okay? Whichever, I'm going to ask Shannon's Copper to give me a number. I'm going to put my pencil down now. I'm going to ask Shannon's Copper, pick a number between 1 and 100. Whichever number you're closer to, I gave a number for the Franks and I gave a number for the Google searches and that. Whichever one you come closest to, we're going to do. So give me a number between 1 and 100. Shannon's Copper. Give me a number between 1 and 100. 333. Come on. Give me a number between 1 and 100. Okay, let's ask somebody else. Sybil, give me a number between 1 and 100. Is Sybil still here? Sybil. Everybody's laughing. You had your chance. Sybil, okay, well, you both, Shannon's copper chose 33. Sybil chose 13. I'm going to show you right now. Stop sharing. Here is the numbers that I put down. Frank's 20, Google 67. You guys are both closest to the Franks with number 20 here. So we are going to be doing the Franks. Shannon, you gave me 333. It doesn't matter. You guys are both closer to the Franks hearing one, so we're going to do the Franks hearing. All right, let me get this back up on screen. Let's get this back on screen. Let's get rid of this. Let's get rid of this. Okay, so the Franks hearing. That was the IGG. Here's the Franks. It is 38 pages, you guys. Now, we are going to be skimming through this, reading some of it, slowing it down, but we are going to get the main part of this is the conclusion. We would be here until 9 o'clock tonight because these next three are all over 30 pages long. So, the judge has decided that he is going to make very lengthy orders. So, let's get going. The Franks order on the defendant's motion for a Franks hearing. Again, we are going to skip this part here, you guys, because this has already been, we know this already. So the parts that I will read are parts that are going to be different from the other motions or from the other orders. Okay, so the defendant is requesting a Franks hearing, claiming law enforcement intentionally, there goes my phone, intentionally or recklessly misrepresented and or admitted several material facts in their probable cause affidavits supporting various search warrant applications. These misrepresentations or admissions, according to the defendant, affect the validity of 17 different search warrants. The state responds that the defendant has failed to make the oh my God. I can't. Substantial preliminary showing under Franks that 1, law enforcement made false statements or admitted material information knowingly or intentionally or with reckless disregard for the truth, and or that the false statements or omissions were necessary to finding a probable cause. These footnotes may give us some more information. We have 1, 2, 3 footnotes on this page. Let's read them. Footnote 1. There was a total of 25 search warrants issued in this investigation between December 23rd, 2022 and August 1st, 2023. I know. Right when your merge mixed up. I don't know what it is, you guys. Like I said, I'm still on my first cup of coffee. I just went and heated it up. I've got a cold, so I'm trying not to cough. And my whole body is aching. Like, you should see my one hand, how swollen it is anyway, it doesn't matter. Anyway, yeah, it's a rough day. Okay. Where were we? Issued it in this investigation. August 1st. For each issue analyzed in this order, the court identified the date range for the specific warrants defendant claims are implicated. Defendant's motion for a Franks hearing was accompanied by a memorandum in support of a Franks hearing and a USB containing exhibits 1,951 pages, filed November 18th. Oh my gosh. 1,951 pages that the defense filed on November 18th. The court subsequently issued, there we go, subsequently issued an order requesting that the defendant file an amended memorandum containing specific cites to the record and revise his original exhibits to include only those relevant to the motion. Remember that when the judge says, oh, hell no, you've got a page limit. It's worse than we thought, you guys. 1,951 pages. Motion. Of a motion. A motion. Wow. Oh, okay. The defendant subsequently, here we go, I got it, subsequently filed an amended memorandum in support of a Franks hearing, which included a USB containing a revised set of exhibits down to 1,010 pages. And when the court addressed them, when they filed this first one of 1,951 pages, he says, you got a 38 or 35 page limit. Get it down. So then they filed one with 1,010 pages. Wow. The revised exhibits, however, only included excerpts of the search warrant affidavits being challenged. To properly consider a Franks motion, the court must necessarily consider the search warrant affidavits, and then that's it. It's cut off. There was more to this, but they cut it off. Okay. Anyway, a hearing on the defendant's motion was held on January 23rd, 2025. That's the one that we couldn't hear. In the interest of evidentiary efficiency, the court permitted a full Franks hearing on the motion only insofar as it pertained to the alleged omission of information regarding the defendant's identification through the IGG. On the remaining challenges, the court permitted argument on the defendant's proffer as to whether defendant had satisfied his burden to warrant a subsequent Franks hearing. The court then took matters under advisement. The court concludes that the standard warrants are not invalid based on the omission of the defendant's identification through IGG because that information would have only bolstered probability cause for the searches. As to the remaining challenges, the court finds defendant has failed to carry his preliminary burden under Franks and therefore denies his motion for a Franks hearing. Kate Bell, thank you. Thank you so much. An open eye with the word sneak peek. Yes. Right? We're going to get some here. We have already found out things that we didn't know. We didn't know that they had snipers surrounding Bryan's parents' home. We didn't know about the chopper above. We didn't know that he was seen going from the kitchen into the garage into the car. So there are things that are coming out throughout all of this, okay? So thank you, Kate Bell. I appreciate you so much. And the $1.99 super chat. Thank you. Yes, thank you, Kate Bell. I really appreciate you guys, with your super chats and supporting the channel. Like I said, this takes up a lot of time. I was going to do an updated read on a case that really didn't take ground today, but I forewent that for this. So I very much appreciate your super chats. Thank you. Okay, so the standard. So somebody was asking earlier what a Frank's motion is, okay? So let's see what they say here. The standard. In a Frank's motion, the trial court's determination as to whether a representation is false and whether a misrepresentation or omission was made knowingly and intentionally or with reckless disregard for the truth are factual determinations reviewed under a clearly erroneous standard. And whether a misrepresentation or omission is material is a question of law freely reviewed. The analysts. For a search warrant to be valid, it must be based on probable cause. Oh, here's the continuation of up here where we said they cut it off up here. Okay, so it's down here. So let's continue to see if we can get any little tidbits in this here. In their entirety, determine whether probable cause is effective. Consequently, the evidence considered by the court for this motion is defendant's revised exhibits as supplements, exhibits D2, D3A, D3B from the original exhibits. References to this order to AM memo mean defendant's amended memorandum. References in this order are revised from the exhibits. This was identified as issue 5 in the defendant's amended memorandum. Let me just take some of my coffee. Okay, so let's read this. The court notes that in response to some of the Frank's challenges, the state submitted and argued evidence that was not included in the defendant's proffer. While this evidence can be considered at a Frank's hearing, this stage only permits the court to consider whether the defendant has made the substantial preliminary showing under Frank's to warrant that hearing. In the United States versus McMurdy, the court should not give the government an opportunity to present its evidence on the validity of the warrant without converting the hearing into a full evidentiary Frank's hearing, including full cross-examination of government witnesses. Consequently, on these challenges, the court is only relying on the defendant's exhibits and the parties. I don't know if drinking a coffee was a good thing to do. Anyway. Okay. So there's that. The Supreme Court held that the defendant could void a search warrant and suppress the fruits of the search when the affidavit is used to procure the warrant contains a knowingly and intentional or recklessly false statement that is material to the probable cause. So where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit. And so these are all just the reasons why the judge could make a different ruling than what he did. But right here, this is what we need to know. I will scroll through to see if there's any little other tidbits. If you do want to read this whole thing, then we can. The one I'm anxious to get to is the Google searches and stuff, okay? So we already know that the court denies his motion for a Frank's hearing. So they're not getting what they want. So let me scroll through this. He's just going over the analysts, the standard for Frank's hearing, and stuff like that. So these are just rules that they have to follow and stuff like that. What a reckless means, a high degree of awareness and probability, falsity. It's just going over what reckless means, what things fall under those headings for reckless or high degree of awareness of probability that something was false, stuff like that, okay? So it's going over here the rules of what a Frank's hearing is and how it applies. He's already denied it. We've seen it right at the beginning, but he is including all this to show what a Frank's hearing is, what things have to be met, etc. Okay, evidence that has not met his Frank's burden on issues 1 and 2, challenges to the Exhibit A. In issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. And see the exhibits. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own, even though it was a product of a collective effort. This is where Ann Taylor was saying that they just copied and pasted certain things in different search warrants and claimed it as their own, blah, 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 right? Like I said, if you do want to read through all of this, you can. I'm just going to give you the breakdown. So the judges said the defendant has not met his burden under the Franks on issues 1 or 2. First, it's not proper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. Anyway, he's denied all this. Like I said, if you do want to read through all this, and these are the reasons why he denied this, feel free. They're going to cite a lot of different cases here. They're going to cite the law on the Franks motions, and he's going to touch base on every aspect of their motion that they claim warranted this to be thrown out and to have a hearing on it. They're saying, like, the defendant's evidence demonstrates there were several law enforcement agencies working together on this case, including the Idaho State Police, the Moscow Police Department, and the FBI. During his testimony from a prior hearing in this matter, Detective Brett Payne from the Moscow Police Department explained that the agents from these 3 agencies were co-located at a command center set up at the Moscow Police Department for purposes of the investigation. These agents were assigned different investigative tasks. Pertinent information they learned in performing this task, then exchanged and transmitted into a working probable cause affidavit. The information from the draft Exhibit A, which was probably a draft affidavit, was then incorporated by law enforcement in varying degrees into the Exhibit A as a supporting the search warrant applications. Importantly, the exhibit as challenged by the defendant included statements alerting the magistrate that the affiant was assisted by other law enforcement agents and that the information contained within the exhibit was based on information provided by these other agents. So they did put in there, and they let the court know that, look, this is a collaboration of many different agencies. So some things are taken from maybe Brett Payne, some are taken from other officers, and they're all going to be incorporated into this probable cause. The exhibit was based on information provided by these other agencies. Blaker Exhibit A, I'm being assisted by other officers of the Moscow Police Department and members of the Idaho State Police and agents of the FBI. So they stated it right there. So for the defense to say, look, they're just copying and pasting what everybody else is saying. No. What happened was they were assigned specific tasks. And when they completed those tasks, got the information that they were seeking, that was then put into the probable cause affidavit from each of those people. So not only do they just take what that person has said, because they're the one that gathered the information, put it in the affidavit, that is also going to be the exact same as what is in their statement, right? So I get it, how the defense could maybe possibly think that they were just doing a lot of copy and pasting, and just using prior investigative techniques or whatever. But they explained it here that this is compiled of everybody's statements from the task that they performed. So you're going to have that officer say an officer went in and, I don't know, found the dirty pillowcases, and this is what I did upon entering. I found these pillowcases, I put them in a bag, blah, 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 and he writes this whole statement. In the probable cause affidavit, they're going to just copy paste that into their probable cause affidavit instead of having to type it all up again, right? So you're going to have that officer statement, which is in evidence, and you're going to have the probable cause, which obviously is in evidence, and they both look identical. Of course they are, because they want you to put into the probable cause affidavit exactly what that officer did, how he did it, where he did it, when he did it, why he did it, and how he did it. So there's no misunderstandings anywhere. So they tried to kind of turn that, right? But anyway, so Exhibit A came not only from the affiant's personal knowledge, but the knowledge of other law enforcement investigating the crime. Moreover, given the breadth of the information in the affidavit, it is readily apparent that the affiant did not perform all the work identified therein on his own. And he did state that. This is when he signed that affidavit. He's not saying, I did all of this, I collected all of this. These are all my statements. He let them know right at the beginning that I am being assisted by other officers of the Moscow Police Department, Idaho State Police, and FBI. So their statements are also going to be incorporated into this probable cause. Okay? So they're saying that probable cause should not have been found because Brett Payne was apparently trying to say that these were all his statements when indeed he was not. So, like I said, we're just going to scroll through this. So if you guys want to read through it, I just gave you the rundown of what happened, what this is all going to say. But the judge does have to put this in the order so they know exactly what is being talked about. Defendant asserts that the detectives both claim to have done the work. They do not. They state they were able to determine the locations after consulting with FBI CAST. Both detectives explain in their respective affidavits that CAST was the FBI's cellular analyst survey team. Thus, it was made abundantly apparent to the magistrate that the detectives were relying on the work performed by more specialized law enforcement agents in determining the cell phone locations. Okay? Because they said that Agent Balance was the individual who actually did the location work does not render the detective statements intentionally or recklessly false or even misleading. So they're trying to say that, detectives are claiming this work as their own when they didn't. So in summary, the statements encompassed in issue 2, the defendant has not established that a misrepresentation took place. Moreover, even if the challenge statements could possibly be construed as false, there is not a shred of evidence that they were intentionally or recklessly false. And he's going to say this through a lot of it. Okay, defendant has not met his Frank's burden on issue 3, eyewitness statements. In issue 3 and 10, the defendant challenges the probable cause statements insofar as they set forth witness DM's interview descriptions of things she heard and saw on the night of November 13th. The defendant claims that law enforcement failed to inform the magistrate that DM's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognize the defendant when provided with a photo of him after his arrest. Okay, so there's where we get a little bit more information. Apparently, they did a photo lineup for DM, who we know who she is, Dylan Mortensen, and she could not pick him out of a photo lineup. That's interesting. Defendant also contends that law enforcement misrepresented statements made by DM that would have demonstrated her unreliability. Okay, so let's read these footnotes because the first one is 15. DM was a roommate of the deceased and was in her own bedroom at the time of the homicides. Insofar as the challenge pertains to omissions regarding DM's reliability and consistency, it applies to all warrants. Insofar as it pertains to her non-recognition of the defendant, it applies to warrants issued after December 30th, 2022. Interesting. Okay, these allegedly false statements and omissions, according to the defendant, were exculpatory and material. While the defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Okay, so this is what the judge is saying about it. Defendant's own proffer establishes that DM's accounts were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavits are very consistent with her accounts. Second, DM's interview statements that her memories were fuzzy and dreamlike may have been affected by being tired or under the influence of alcohol. do not call into question her reliability to the extent of a Frank's would require disclosure. Finally, DM's failure, here we go again, to recognize the photo of the defendant is of no consequence, given that the intruder she saw was masked. DM's accounts were consistent and accurately summarized in the exhibit as the draft Exhibit A circulated by law enforcement included the following description of statements DM made during her interviews with law enforcement. We're going to get some of her statements, you guys. Are you ready? So Dylan Morrison made statements during interview that indicated the occupants of the King Road residence were home by 2 a.m. and reportedly asleep by approximately 4 a.m. This is with the exception of Kernoodle, who received a DoorDash order at the residence at approximately 4 a.m. DM stated she was awoken at approximately 4 a.m. by what she stated sounded like Kaylee playing with her dog in one of the upstairs bedrooms, which were located on the third floor. A short time later, DM said she heard who she thought was Kaylee say something to the effect of "there's someone here." A review of forensic records associated with the download of Zaina's phone indicated she was likely awake and using TikTok app at approximately 4:12. Dylan Mortensen stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. Dylan stated she opened her door a second time when she heard what she thought somebody crying from Zaina's room. Then she said she heard a male voice say something to the effect, "It's okay, I'm going to help you." At approximately 4:17 a.m., a camera at 112 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Zaina's bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard on the camera. Dylan stated she opened her door for a third time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking towards her. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past Dylan as she stood in a frozen shock phase as the male walked towards the back sliding glass door. Yeah, he had to walk past Dylan's door and the bottom of the stairs leading to the third floor to get to the kitchen, because the kitchen would be to the right of the stairs and Dylan's door, to get out the back sliding glass door. Dylan locked herself in her room after seeing the male. Wow. The proportion of the draft exhibit was incorporated in various degrees into Blaker's Exhibit A. Okay. So when these were submitted in support of search warrant applications, Dylan had sat for at least 3 interviews with law enforcement, 2 on November 13th and 1 with Officer Nunes, and later 1 with Detective Mowry, and 1 on November 17th with Detective Gooch. Her description of the intruder was notably similar during all 3 interviews. A white male, slim, skinny, lean body type, slightly taller than DM. Dylan was 5'10", wearing all black, wearing a mask that was covering his forehead and mouth. We have learned that it was like a ninja style mask that he had on, where there's just cutouts for the eyes. Not mask, but like a balaclava almost, but just the cutouts for the eyes could be seen. So like a ninja mask. Now, I don't know how somebody found that out. Maybe it's in here. I don't know. Let's see. But it was covering his forehead and mouth, a voice she didn't recognize saying he was here to help. And the intruder walked out towards the back sliding door without saying anything to her. Okay, Sybil, we don't mention other channels here, please. I did remove the comment. We do not mention other channels here. Okay, so, and then she said the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunes that she noticed the intruder carrying a vacuum-type object in his hand. What? So here's something else new that we're just finding out. Well, she did not tell Officer Nunes that she noticed the intruder carrying, you mentioned another channel. I'm not going to re-mention it, but okay, so a voice she didn't recognize saying he was here to help. Okay, let me go. I don't. It starts with Justice for. Okay, so unless you were just saying you're hoping for justice for all these precious lives. I get you now. You're saying justice for all these precious lives. I get it. Okay, Sybil, I apologize. Because that is also a channel name. There's no need to leave, but that is a channel name, so I apologize. I get what you're saying now that, yes, we want justice for all these 4 precious lives. I get it. No, don't apologize. That was, I took that out of context of what you meant by it, because there is a channel with that name. So no, don't apologize. It's okay. It's okay. It's okay. It was my mistake. No need to apologize. Please forgive me for taking it the wrong way. Okay, so now we're finding out the intruder. Okay, where was that? She did not tell Officer Nunes what she noticed the intruder carrying. Sybil, no, it's okay, hon. Don't worry. She noticed the intruder carrying a vacuum type object in his hand. What do you guys think that could be? What do you think that could be? Because I've never heard this before. A vacuum type like object in his hand. What is that? Is that, I don't know. I don't know. I don't know what that could be. She did convey that information to Detective Mowry later that day, as well as Detective Gooch a few days after that. Much love to you too, Sybil. So she also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their color. Likewise told Detective Mowry she could not remember the color of his eyebrows. Ooh. No, you don't need to do that, Sybil. It was my mistake, not yours, honey. Peach cobbler. Good question. Whatever that was in his hand, could he have had something that he did wrap the knife in? Good catch, Peach cobbler. Good catch. Good catch. Much love to you too, Sybil. Okay. So more importantly, not only are DM statements consistent with each other with regard to the intruder's description, they were accurately included by law enforcement in the exhibit as set forth above. Yes, Kate Bell's saying the same thing. That could very well be. Good catch, Peach cobbler. There's not one statement in the affidavits regarding the intruder that cannot be traced directly to DM's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of material exculpatory fact with regard to law enforcement's recounting of DM's description. So there's lots of exhibits listed at the bottom of this page, you guys. Okay, defendant also asserted that Exhibit a watered-down DM statement about hearing Kaylee around the time of the homicides. According to the defendant, DM was unequivocal in her 3 interviews when she reported that approximately 4 a.m. she heard Kaylee walk upstairs with her dog before running back downstairs saying someone's here. What? So, which one is true? You guys, this is interesting because in the probable cause affidavit, Dylan stated that she thought she heard Kaylee upstairs playing with her dog around 4 a.m. Like the banging on the floor, the thumps that she was hearing. She thought that it was Kaylee playing with her dog. But now we're seeing that the defendant is saying that there's an exhibit that's probably under seal that officers watered down Dylan Mortensen's statement, that her actual statement was that she was unequivocal in her 3 interviews when she reported that approximately 4 a.m. she heard Kaylee walk upstairs with her dog before running back down the stairs saying someone's here. What? I don't get that. Now, let's discuss this. Because if that is true, I don't know. Because that would then mean that Kaylee wasn't initially upstairs in Madison's room. If this is true, was she maybe in Zaina's room, came out of Zaina's room, was going upstairs with the dog, put the dog in her room, and then went to see Madison before going to bed? And that's when she seen the assailant stabbing Madison, and she tried to stop it, hence why she was up in the corner of the bed? I don't know. It doesn't make sense. Excuse me, you guys. But this is all going to come out in trial, right? But that doesn't make sense. Because if she ran back down the stairs, she wouldn't have been deceased in Madison's room unless she just ran back down the stairs going, hey, you guys, there's somebody here in Madison's room. And she ran back upstairs to help Madison, thinking that somebody was just maybe trying to SA her or something, and she was going to help get this guy off of her. And this is when it all happened. That could very well be. But wouldn't all the other roommates would have run out and ran upstairs too? You know what I mean? I don't know. I don't know how it's going to come together. I don't know. However, law enforcement represented that Dylan said she heard who she thought was Kaylee say something to the effect, there's someone here. Defendant argues the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that Dylan was wrong about what she heard. Defendant points out that Kaylee was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan heard running down the stairs at 4 a.m. Defendant contends that Dylan misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. However, the statement challenged by defendant can be read in 2 ways. That Dylan said, I think it was Kaylee, which is how defendant apparently reads it, and which he claims inconsistent with Dylan's interview statements, or 2, that Dylan said she heard Kaylee, but law enforcement had reason to think it could have been someone else. When the statement is viewed in context, the latter makes more sense. In their respective exhibits, as Detective Payne and Sergeant Blaker immediately followed up the challenge statement with the following. A review of records obtained from forensic download of Zaina's phone showed this could also have been Zaina, as her cellular phone indicated she was likely awake using TikTok app approximately 4:12. Payne Exhibit A at Bates 5161, Blaker Exhibit A at Bates 52, emphasis added. Through this explanation, Plain and Baker are effectively conveying to magistrate why they believe Dylan's statement of who she heard was questionable. Thus, the court cannot conclude there is anything false or misleading in the regard. Okay. That's interesting. That's interesting. We're going over this because this part here, page 13 out of 38 pages, is giving us more information about what Dylan said, what, you know what I mean, what was in all the paperwork, police reports, this and that ended up getting put together and put it into the probable cause. We're hearing it all now, right? In addition, even assuming it was a false statement, the defendant has not established that it was an intentional or reckless attempt to hide Dylan's alleged misperception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a Frank's hearing is not warranted in regard to the statements in the relevant Exhibit A as regarding Dylan's account of what she saw and heard. 2, there is no evidence law enforcement intentionally or recklessly admitted information bearing on Dylan's reliability or such omissions were material to probable cause. Wow. Defendant next asserts that the probable cause statements omitted important information bearing on Dylan's reliability. The defendant notes that Dylan's qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mowry everything was kind of blurry, like I don't fully remember it, I would say. A few days later, while recounting the events to Detective Gooch, DM stated again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. I just have no clue. Well, we know it's real because there's 4 dead bodies there, right? She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or if anything is a dream. Well, we know it's real because there's 4 dead bodies. This information was not included in the exhibit as, according to the defendant, this information was crucial to allow the magistrate to properly evaluate Dylan's reliability, and its omission was material and exculpatory. The law does not favor defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decisions, whether giving all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. So you can read this bottom part again, but so whether the hearsay supplier is reliable is dependent in part on their status. Unlike an informer from the criminal milieu, crime victims or witnesses are presumed reliable and may be relied upon without independent corroboration. Okay, so he's giving the rules on it here. None of DM's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as to the facts relied on the search warrant affidavits. Despite the fact she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Further, even in her reliability were in question, There was other evidence included in the exhibit that corroborated her account. For example, the security camera from 112 King Road picked up the audio of a struggle at 4:17 a.m., which coincides with DM stated she thought was crying from Miss Kernoodle's room and a male voice speaking. It was shortly after this she opened the door for a third time and saw the suspect walk by towards the sliding glass door, which corresponds with the surveillance video showing a suspect vehicle leaving the 1122 King Road at 4:20 a.m. In addition, law enforcement corroborated DM's description of the defendant through its vehicle identification efforts, which led investigators to defendant's driver's license information. The exhibit as note that the defendant's physical description was consistent with DM's account. Defendant has shown no objective indication that DM's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly admitted the information. Further, the exhibit has inferred that DM was traumatized when they noted she stood frozen in shock phase when she saw an intruder. This necessarily alerted the magistrate that DM's memories were colored by trauma and shock, which goes to the issue of a reliability that the defendant targets in this motion. Finally, even had the exhibit as included DM's qualifications into her memory, it would not have significantly undermined her credibility and would not have negated probable cause. It would be no surprise to the magistrate that a person experienced what DM must have experienced would be shaken by what happened and would have questioned the reliability of what she perceived. But she didn't know what happened, right? At this point, when now, I guess so, given when she was giving the statement, yeah, she knew what happened. Okay. But during these opening and closing and checking of the door, she didn't know what was going on, right? So I get it. Okay, so now they're questioning her. They're talking about when they questioned her. Because I know a few people are going to say, well, she didn't even know what happened. Why would she be traumatized? This is after the fact, after the bodies were found and everything, and they're questioning her. Okay. Additionally, the bulk of the probable cause came from other sources, including the extensive vehicle identification efforts. Thus, even if the magistrate questioned the reliability of DM's account, she had sufficient grounds through other evidence to issue the warrants. In sum, the defendant has not shown that DM's various qualifications to her memory are material exculpatory facts that were intentionally or recklessly admitted and that would have affected a probable cause. It is evident from the applicable exhibits A's that DM's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify the defendant specifically. Her statements on these matters were consistent. While any perceived weaknesses in her memory may be fodder for cross-examination, they do not negate probable cause. Consequently, Frank's hearing is not warranted. DM's non-recognition of the defendant is immaterial. Defendant also contests that law enforcement's failure to include DM's non-recognition of the defendant warrants Frank's hearing. I don't know. So, during her December 30th, 2022 interview with law enforcement, DM was shown defendant's mugshot and asked by Detective Lake whether defendant was the person she saw in her house. DM responded, I have no clue. From what I remember, I just remember seeing this figure that was more of like a skinnier tone build and some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white, but I didn't know how he was white. What? I just knew he was. And I knew he looked at me because of the bushy eyebrows. However, the fact that Dillon could not identify the defendant is hardly exculpatory or material to probable cause. So the omission of non-identification from a photo spread was not material, and that the Fourth Amendment does not require an affiant to include all potential exculpatory evidence in the affidavit. Her interview statements consistently describe a black-clad masked person who was not someone she thought she knew or could identify. Her inability to recognize the defendant unmasked is expected, particularly where her description is relied in the exhibit as describes a mask that covered the person's mouth and nose. Thus, because her non-recognition is non-material and exculpatory, defendant cannot demonstrate the failure to include this fact in the probable cause. I know they did give it over in evidence, but just because it wasn't in the probable cause doesn't mean that they didn't get it, right? Obviously, they got it because they're fighting about it. The defendant has not demonstrated law enforcement admitted it intentionally or recklessly, nor has he shown how including the information would have affected a probable cause. Well, that could be debated. If I was a defense attorney, I probably would have argued this too, that should have been in the probable cause, that Dylan could not pick him out of a lineup. So, one for Ann Taylor there. I do kind of sort of agree with her there. But on the other hand, I understand why she couldn't. If the only thing she could see was his eyes, bushy eyebrows, I get it. You're not going to be able to pick somebody out. And when they do photo lineups, you guys, because I've had my clients, when I was working in law, my clients were hauled into photo lineups. And it's not unusual in a lot of situations for the victim or witness not to be able to pick out the defendant in a photo lineup. And this is an example of 90% of him was covered, right? So now you see him with nothing on him, probably in just a t-shirt and pants. You know what I mean? It's not unusual that she couldn't pick him out. But with that being said, I feel they should have put it in the probable cause. Defendant from photo, the magistrate would not have found probable cause. I think they still would have found probable cause with all the other stuff combined. So he's not giving a Frank's hearing on that. Okay, so a lot of this we're going to skip through because I'm going to go through it slowly here just to see if there is any new information in here. Okay, this is what they do. Suspect vehicle captured through various surveillance cameras. Now we know that his vehicle was captured on the one by the gas station. They've also stated in other court documents that on the main highway coming from Pullman into Moscow, there's a restaurant or coffee shop there that also caught him. They also said that there is another residence that caught him too. So this is when they were arguing that they gave the wrong year. So they're arguing about here, this all, the draft exhibit A, this is all about arguing about them giving the wrong year of the car. At first they gave 2011 to 2013, and then they gave 2011 to 2016. So these here, I'm going to go through them slow. So if you do want to read them, I'm going to scroll through it slow. You can watch it on the replay. But I will pick out anything that is new. Okay, so yeah, she must have been. Peach Collar says I'm getting chills. Yeah. So regarding the car, Let me just move my mic over a bit here. Bear with me, you guys. Okay. Um, with the challenges, when they first said it was between 2011, 2013, and then they put it out to a 2016, they're saying that the defendant challenged the exhibit on the grounds that the FBI vehicle specialist identification of the suspect's vehicle as a 2011 to 2016 Hyundai Elantra was based on video footage from Ridge Road. Ridge Road. That law enforcement knew or should have known was not suspect vehicle one. Defendant states that he knows law enforcement based identification of the vehicle on the Ridge Road footage because we have emails from the FBI specialist who explains on November 23rd that their team is mainly looking at the window configuration, something these other images do not. But later that day, an FBI agent sends them images from this video, calling it Great One. However, the defendant's proffer does not show FBI specialist identification was in fact made on the Ridge Road footage. Okay. Okay, so this may be interesting here, you guys. Defendant has not met his Frank's burden on issue 5, misleading timeline. So in issue 5, the defendant claims that law enforcement created a false narrative of their investigative timeline in Exhibit A as to make it appear that the defendant was identified through their investigative efforts and not, in fact, through the IGG. But see, what they don't realize is there was other things that they had gotten. They got Dylan's description, right? They got video from the house right beside. Later on, they got video from other sources, but initially, what else did they get? They got a call from a Washington State University cop that says, hey, look like when you guys put out this description of the vehicle, I went and checked our roster and we have a guy here that fits, that car. And it has out-of-state license plates on it. So I don't know if you guys got this car on video, but it's very distinctive because it has no front license plate. Idaho requires both front and back license plates. So does Washington, whereas Pennsylvania does not. You only need a rear license plate. So that is one identifying factor that, probably puts other Hyundais from the area out of question because they would have front and back license plates, right? See, here it is here. That same day, Detective Payne states that another Washington State University officer was patrolling the area by the defendant's apartment and located a 2015 white Elantra with Washington plates. He ran the plate and it returned to the defendant. Points out that Detective Payne was not even aware of the WSU officer's findings in this regard until December 20th. Defendant was already identified by IGG. However, he contends Payne's exhibit made it appear the defendant was identified in part through the WSU queries. Well, he called it in before that, before Bryan changed his license plates. Right? Oh, thank you, Sybil. I appreciate you. Thank you so much. Because we do know that in one of the documents, the Washington State University security said, look, we got a vehicle like that here, but it has no front license plate. So, like I said, this here doesn't really matter. We're going to get into the IGG in a little bit. But he's denied this motion. Okay, so here's the next one. Defendant has not met his Frank's burden on issue 6, the dog barking. In this issue, the defendant challenges omissions pertaining to the barking dog reference in the Payne Exhibit A. It states that at 4:17 a.m., a security camera located at a nearby residence on King Road picked up a distorted audio of what sounded like voices or a whimper followed by a loud thud. A dog can also be heard barking numerous times starting at 4:17 a.m. Exhibit D3B at Bates 5161. The only other information in the Payne exhibit pertaining to the dog refers to the fact that Kaylee's dog, Murphy, was found in her bedroom by first responders. Now, that would be the same outside wall closest to that house that picked up what it picked up, right? Thank you again, Sebo. I appreciate you so much. Good morning, Summer. Summer Dawn. Good afternoon. Actually, it's just past 12. Okay, so let's get through this. According to the defendant, the submitted information. Okay, defendant contends failed to include 3 allegedly important pieces of information to the dog: that the dog heard on the security camera continued to bark for 30 minutes after the suspect left. 2, that Detective Payne conducted a test to determine that the dog was likely outside while barking. And 3, Murphy was found without any blood on him, even though the bedroom doors were open where the decedents were found. According to the defendant, because apparently Kaylee's door was closed and the dog was inside Kaylee's bedroom. I don't know. Further argues this information is material and exculpatory because it undermines the narrative and timeline that supports probable cause. However, the defendant's arguments assumes without proof there were no doors left open in the home after the suspect left. This assumption is not only speculative but contrary to evidence and is proffered that the sliding glass door to the residence, the same door towards which DM reportedly saw the suspect walk, was left open. Well, generally, when there's people that break into your place like this, they're not going to stop to close the door after when they're on their way out. Number 1, it's going to make more noise, and number 2, it takes more time. Thus, if the dog heard barking was in fact Murphy, it could have come back inside through the open door and gone to Miss Gonçalves' room on its own, where it evidentially remained. There is simply no evidence to adopt the defense speculation that someone brought Murphy inside after the suspect left the residence. Consequently, the defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory admission that was intentionally or recklessly excluded. So then the cell phone data, they're going to go into the geo-forcing and everything about his phone. Like I said, if you want to, all of this has been denied. So if you do want to read through this, I am going to scroll through it. This is when they're talking about, defendants turning off their phone or going into airplane mode, blah, 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 blah. This also goes on to when they seen the phone go off, when they seen the phone go on, which really throws Bryan Kohberger's alibi out the window, because his phone is never seen over in that area in Washington. It's like 40 minutes, 40 minutes from his apartment the other way, away from Idaho. So I guess going west is about 40 minutes from his apartment in Pullman, whereas his phone and the GPS tracking and everything never got him over in that area. His phone came back on at 4. It went off just before 4 as he was heading towards Moscow. Came back on just after the crime happened. Is still in Idaho, going north in Idaho, and going back towards his apartment. He's going south. South of the 1122 King Road house. He goes south, and then he goes west, and then goes north back up towards Pullman. So there's that. A challenge to the timing of the second AT&T warrant. This was also denied, but I will scroll through it. So if you do want to read this, you can just go back and pause it as you're reading. It's all been denied. And like I said, you guys, before, just because Ann Taylor states something as fact, it doesn't mean it's fact. She can claim whatever she wants. She can interpret things the way that she wants to interpret them. It doesn't make it true. Okay? I feel like a lot of people are saying, see, Ann Taylor said this, so what the prosecution is saying is not true. No, that's not how it works, you guys. Right? Just because she's in a lot of these motions, she's saying it from her point of view and how she understands it and how she is evaluating the information. It doesn't mean what she thinks, how she is looking at it or interpreting it or reading it or coming to her conclusions. Don't mean that those are true either. Okay? The proof is going to be in the pudding. The pudding is all going to come out at trial. Okay? Now, in here, we see what the prosecution is proving what she's saying is not true or is false or is misleading. Okay? Now, I mean, Bryan Kohberger cannot ever claim insufficient counsel. Like, she is doing things that have gone, no pun intended, above and beyond what state paid attorneys would usually do. She has gone to great heights to do everything and throw everything at the wall to see what would stick. She's doing everything. I don't blame her. She has a job to do. This is also her reputation on the line, right? I do believe she knows this is going to be probably the first one she doesn't win. She knows it. They know their case is weak. Their alibi has been blown out of the water that there's no way it could happen. They've got nothing. So when you got nothing, you have to attack the best evidence that the prosecution has. You have to play on every word. You have to do stuff like this. Do stuff like she did with bringing up the 1800s law. And this is the way our forefathers, meant it to be carried out. And this law and that law, which we all know have been changed for hundreds of years. New precedents set. New cases to cite where different judgments have been made and are now a precedent. You know what I mean? She knew, but she's doing everything in her power, regardless of how ridiculous it sounds. But a 1,900-page motion, that was pushing it. I thought 138 or 400-page motion was bad, but 1,900 pages? Ooh. Nana says still morning for me. Well, good morning, Nana. So I think that she's really trying to throw as much shade as she can and pick apart every little thing that she can and put her interpretation of things into a motion so it can be seen by us to maybe kind of sway us a little bit more. Doesn't mean what she's saying is true. Okay? It's her interpretation, just like this is my interpretation. Do your homework. I'm not saying I'm wrong a lot. But what I'm seeing here, being as I did work in criminal law for 30 years and did tons of cases, nothing like this case, not even close. Maybe a single murder, yes, but nothing like this. It's still the same formula that's used. The only addition here is it's a death penalty case. Okay, so there's an added case within a case, you could say. Um, I don't blame her. Am I irritated by it? Yes, because I want this to get to trial. I'm irritated by it, but I know why she's doing it. Okay? I know why she's going to every ends of the earth. You can't blame her for that. Her reputation is on the line. Summer Dawn, thank you so much for your $5 super chat. Well, thank you. And I love you guys too. So I can see here, you guys, like I said, I will go through this slowly. So it's 38 pages. We're at page 26 here. I want to get on to the next one. We'll take a little bit of a break before we pull up the next one that we're going to go over. Everybody can go run to potty. We've been here for 2 hours, you guys. Run potty. I'm going to make another hot tea. So I'll make that and then we'll get back to it because the next one I think is like 30 something pages too. But that is the one I am most interested in. This one here, we got a lot of the Dylan Mortensen stuff. There's still more in here that we're going to go over. But the next one is the one that spills some tea, right? Okay, let me turn my monitor a bit here. Here we go. Okay, where were we? What were we on here? See, there goes my memory. Okay. Okay, so we're down here. They're talking about the videos. Okay, where were we? Okay, we were here. Okay, so another thing I'm going to bring up, you guys, is coming up here. I said I'm just scrolling through this. Where did I just see his name? Hang on. I just seen his name. Ugh. Okay, right here. I'm going to bring something up for you. Hang on. I'm trying to find this, guys. The one that I did have is now behind a paywall. So give me 1 second here. Yeah, that's not it. I'm not paying for this. But I will. This is the Colorado Springs Gazette. I don't know if it's just because I'm in Canada, but I'm going to put the link in chat. You can go and read it. But this is telling you about the unreliability of Cy Ray. They don't use his technology anymore. It's been known to be unreliable, false, misleading. I do believe Colorado had a contract with Cy um, for his technology. He's a retired cop, um, and the courts stopped the contract. They bowed out of the contract. The judge says your technology is unreliable. We're not going to be using you anymore. It's found to be with a lot of glitches, and it's not. It doesn't do what it's supposed to do. Okay, so it has been banned from several jurisdictions. Now I don't know about here in Idaho in this case, but I know in several jurisdictions it's banned. I don't know if it's been across the board, but anyway, they're using this Cy. Like Wade said, he has reviewed multiple search warrants, affidavits prepared by Detective Payne, and a statement that defense cell phone stopped reporting to the network at 2:47 is blatantly false. Well, I don't trust anything, and he's going to get ripped apart on the stand. Okay, his technology is going to get ripped apart. It's unreliable. It's been found by many, many judges and courts to be unreliable. A lot of people that were convicted on his technology have since been released, and there's tons of court cases pending because of the Cy technology that was used in their cases, and it has now been found to be unreliable and completely garbage. So there's that. And these are the type of experts that Anne is getting. And to me, it's like, is this the only one she could get? Is somebody who has been basically shunned, government contracts canceled on him because his technology that he uses is full of garbage. It's basically garbage. It's full of inconsistency. It's full of errors. It's unreliable. It's garbage. And it's been ruled as that. There's been people that have had their sentences overturned because of this guy. They were convicted because of Cy technology. Okay? And the technology that he created, he's an ex cop. He claimed to be an engineer. He's not. He's an ex cop. Anyway, there's that. You guys look it up. Thank you again, Summer Dawn. Nana says, if that's the case, then the prosecutions have a real problem. No, the defense has a problem. It's the defense that's using this witness, Cy and using his technology that tracks GPS tracking and cell tower data and stuff like that. And it's been proven that this guy's technology is garbage. His contracts that he had with the government were canceled because when they tested the equipment, it was garbage. It wasn't reliable. It was off. It didn't give the statistics and the data that he claimed it did. So, and this is the one that the defense has hired. So, Cy can say whatever he wants and try to rip apart what the government has done regarding cell phone data and GPS tracking and all that. But once the prosecution gets to cross-examine this guy, they're going to destroy him. Destroy him. Because this is being called, Cy this guy is being called as a defense witness. Okay? Cy yeah. I've got the link there in chat. I can't get to it. It's behind a paywall. I don't know if that's just because I'm in Canada, but people have had their cases overturned and are now set free because this guy, Cy and his technology was proven to be garbage. That's why the government canceled the contract they had with him to be able to use him. So Ray, bye-bye. But I'm just, it's sad that this is the only person that they could get to try to debunk cast and all that, which is known and proven to be accurate and spot on. You know what I mean? Like, this is the guy that you're going to get to try and debunk what the prosecution has as far as GPS and and cell phone data and eh, cell phone data, cell tower data. What? Anyway, so you can read through this if you want. Um, let's see what the judge says if he makes a comment about this guy. Because this here is all regarding the cell phone data, tower data, GPS. Okay, so here is what the judge says. When the extent of evidence recounted in the pen register affidavit is considered a whole, it is evident to the court that had Detective Payne stated defendant's cell phone was traveling southbound from Pullman when it stopped reporting at 254, there is still enough probable cause linking the defendant to the homicide to justify the issuance of the search warrant. Consequently, Frank's hearing is not warranted on this issue. So this is going to be still probably Ray, um, that has his paws on this part too, that the defendant has not shown any omission regarding cell tower coverage area was reckless, intentional, or material. The final claim raised by the defendant is that Detective Payne omitted important information about cell tower coverage in Moscow when he stated the records for the 8458 phone, okay, I got an update from my Geoforce driver. Okay. Anyway, they're saying that he omitted important information. This is probably going to be Ray saying, "Oh, that's not true. This is what I found." Blah 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 blah. And the judge found again that they haven't met a burden. It's denied. The grand jury subpoenas, issue 11 faults law enforcement for omitting information in the exhibit supporting the search warrant for Amazon records, which was issued May 8, 2023. Specifically, asserts that the affiant Detective Mowry requested the warrant in reliance on a federal grand jury subpoenas issued by the FBI to Amazon, but did not tell the magistrate information about the timing and scope of information obtained and relied upon. So this is regarding warrants and stuff like that that was issued, so they could go in front of a grand jury to get the indictment. It's been denied. Frank's hearing is not warranted. And what the judge said is what this challenge appears to be is an attempt to use Frank's as a means for discovery, which is not its purpose. So Frank's hearing is not warranted. Issue 12, defendant challenges law enforcement admission in their exhibit as of the fact that their investigation failed to reveal any connection between the defendant and the victims. Defendant claims this information was material and exculpatory because it sheds doubt on how law enforcement's theory that defendant was the right person. However, the defendant has not established the lack of connection was a fact conclusively known to law enforcement at the time of the search warrant was applications were submitted. Thus, he cannot establish it was intentionally or recklessly omitted. Moreover, this omission was not material or exculpatory. Had law enforcement found a connection between the defendant and the victims prior to applying for the search warrants, it is reasonable to assume the connection would have been disclosed in the search warrant. So what does this tell us? What's this tell us? Had law enforcement, so they're saying, let's back up. They're saying in their probable cause affidavit, they're saying that that they couldn't find revealed to, okay, they're saying, as of the fact that their investigation failed to reveal any connection, listen to these words. The fact that their investigation failed to reveal any connection between defendant and the victims. Defendant claims this information was material and exculpatory because it sheds doubt on law enforcement's theory that the defendant was the right person. But wait, this is for the indictment, right? Now, since then, because this has been fluid, this has been an ongoing investigation. Look it down here. However, defendant has not established the lack of connection was a fact conclusively known to law enforcement at the time the search warrant applications were submitted. Thus, he cannot establish it was intentionally or recklessly omitted. Since then, in my opinion, okay, they have found connections now because of this statement. Had law enforcement found a connection between the defendant and the victims prior to applying for the search warrant, it is reasonable to assume the connection would have been disclosed in the search warrant affidavits. The fact it was not disclosed necessarily allowed the magistrate to reasonably infer that no connection had yet been found, yet she still found probable cause to authorize the search warrant, which means they have found a connection. Somewhere, somehow, there is a connection that was found. They just found it after they put it in this warrant. I don't know. Defendant has not met his Frank's burden. This is for the Frank's hearing, you guys. Lack of victim DNA in the apartment. So you can read through this. So what they're saying is that, however, okay. The defendant challenges law enforcement admission in the exhibit as the fact that lab testing performed by the Idaho State Police did not reveal the victim's DNA in the defendant's vehicle or his apartment. Defendant contends the lack of DNA is devastating to law enforcement's theory of the case and was intentionally or recklessly omitted. However, as with the prior issue, defendant has not established when law enforcement knew the lack of victim DNA in the defendant's vehicle and apartment. The 3 ISP lab reports relied upon by defendant were issued on March 2nd, March 8th, and March 23rd, 2023, respectively. Thus, it cannot be said law enforcement knew of the lack of DNA until the last report was issued. And the probable cause was issued long before this. So, let me see. He asserts that he has reason to believe that the results of the testing were verbally transmitted to law enforcement at the time. However, the evidence submitted by the defendant does not support his assertion. So there was hair and fibers collected from the crime scene that were not consistent with the defendant's hair sample. I want to know about the dog hair that was found, the pet hair. Yeah, see, at best it can be said that the law enforcement was aware as of February 28th that the FBI testing did not reveal the victim's hair fibers in defendant's apartment or vehicle, but it is evident from the various lab reports that law enforcement's investigation with regard to DNA was still continuing. Therefore, there was no basis for law enforcement to definitely aver there was an absence of victim DNA in the vehicle and apartment until the final reports were issued. In other words, defendant has not demonstrated an omission, much less that it was intentional or reckless. That is... So we denied a Frank's hearing on that. Here's the IGG. We're going to go over all this in another order, and I think we're going to have to break this down over a couple of days because this is just too much. See, in issue 8, defendant challenges law enforcement's omission in exhibit A that defendant was identified through an allegedly unconstitutional use of IGG. He contends law enforcement should have disclosed in exhibit A that the methods used by Othram Labs to conduct the IGG testing allegedly did not meet minimum standards, that the FBI failed to document its own IGG search using Othram's data, and that the FBI manipulated Othram's data to create a much larger DNA profile, and the FBI violated its own policy in that of the commercial IGG databases when it uploaded the DNA profile to databases restricting law enforcement use. Defendants contends these omissions from Exhibit A were purposeful. He also argues the omissions were material and exculpatory because they would have undermined probable cause. But they didn't arrest him on that. It was a lead that the FBI gave to Moscow police saying, hey, this is what we've got. Here's a name. Figure it out. Here's a name that we think may very well be connected to your case. Go investigate it. The name was Kohberger, right? Then these pieces started falling together, right? They started running his name for any criminal activity. Oh, look at that. He was stopped in the area not once, but twice. Oh, and look at that. He drives a white Hyundai. Oh, and look at that. When he was stopped, he gave his phone number. Let's search that phone number with GPS, see what he was doing that night. Oh, and then we got Washington State University cop calling in saying, hey, we got a Bryan Kohberger that lives here that has a white Hyundai Elantra with no front license plate. Oh, look at that. They got the camera from where he would have had to come down and then turn onto to Queen Road, to the 112 King Road. It's actually called Queen Road, but they're saying King Road. So right when he has to make that turn, there's a camera at that little house right on the corner that would have caught him with no front license plate. And that camera, I've seen images of it. It's really, really clear. And here comes that white Elantra that came from the area of Pullman, Washington. The times and GPS and everything line up. And here it comes. And it circles and circles and circles and circles and circles. And then as soon as the murders happen, boom, he's gone. He comes back the next morning and is there like seconds just to see what's going on and takes off again and never comes back again after that. And the defense is trying to say, look at, he goes for drives, he goes there often, all the time. But he no longer goes there after the murders. What? He can't produce the K-bar and sheath that he bought? What? He can't produce the Dickies that he bought at Walmart? What? And it's funny that he was clad in dark clothing with face coverings, and it was a K-bar knife used because it got the sheath with his DNA on it. And he can't produce his sheath, his knife, or his Dickies that he just purchased. What? There we go. So that's this. So like I said, the conclusion, based on the foregoing defendant's motion for Frank's hearing, denied. That was 38 pages, you guys. Now, if you want me to go through the next one, we're going to have to take a 5-minute break. So we've gone through this one. Now, there's one here that's 29 pages for the IGG. I think we know enough about this, but we can go through it. This is the one I want to go through because there's going to be a lot of information. This is 36 pages. This one we already went through. This one we already went through. So we got 2 more to go through, you guys. If you guys want me to wait and go through this maybe tomorrow morning, we can, and just start up another live on it. Or let's take a 5-minute break so people can go grab a coffee. I want to go, and I just heated this one up, so I'll make a fresh one. Take a little break, give my throat a little bit of a rest, and we can come back and go over. This is the one I've been waiting for. The order on the defendant's motions to suppress the AT&T, Google, USB, Apple, and Amazon. This is the one that I've been waiting for. Do you guys want to do it right now? Put yes or no in the chat. I will wait. Okay, we'll do a vote. We'll do a vote because I know a lot of people don't like typing to chat. So let's do a vote. Hang on. Okay, there it is. Yes or no? Do we go over the next document? Read the Google. This is going to be the one that is showing on your screen. Okay, it seems like a lot of people want me to go over it. 80% want me to go over it now, so that's what we are going to do. We are going to go over it now. So what we're going to do is we're going to take a 5-minute break, get up, stretch your legs. I know I got to. I've been sitting here for 2.5, almost 3 hours. We've been here 2 hours and 43 minutes. So I got to get up, stretch my legs a bit because my back is starting to get stiff. I will make a coffee, use the potty one more time. And then guess what? We're going to go over this one because this is the one that I have been most anxious to see. Don't forget, a lot of this was argued in that hearing on January 23rd that we could not see or hear or stream. A lot of that is going to be in here. Okay? Kate Bell says, I'm making a long drive. Kate Bell, I am 3/4 of the way done your diamond painting. Okay, so we're going to go on a 5-minute break. Uh, okay, there we go. Okay, we got 5 minutes, you guys. Take 5 minutes, get up, stretch your legs, and we will be back. And we will go over this. It is 36 pages. This one is going to be really interesting, and we may get some more facts here. Okay? So go do what you got to do. Make a coffee, make a drink, get a beverage of your choosing. Go potty, whatever you need to do, because we're going to get into this as soon as we come back from break. See you then. Okay, I am back. I've got a fresh coffee. What happened to chat here? Okay, let me get chat back up, you guys. Kate Bell says, driving down to Detroit. Not that long, but it's long with the snow, yeah. I was so mad, you guys. I spent hours, I go out for 20 minutes at a time to shovel through this 5-foot snowbank that covered the sidewalk. You guys can see the pictures on my community tab. So I did that all day Tuesday. Yesterday, guess what goes down the sidewalk? The big city cleaning sidewalk thing that goes down and takes all the snow off. They went through snowbanks that were 12 feet tall. They went through it and cleared all the sidewalk. And it's like, are you kidding me? So I killed myself. My hand is so swollen. It's unreal. You can barely even, you can't see where my knuckles are. The snowblower kicked back on me and caught my hand in between the side of the house and the snowblower. My hand was on the grip of the snowblower. And it's like, oh my God. So now my hand is so swollen, I could barely even move it. And the very next day, this big machine goes down the sidewalks and cleans all the sidewalks. I was pissed. But I had to clean it because I couldn't even get to my car, without going all the way down, trying to climb through or over 12-foot snowbanks. It was, anyway, so I feel you. I feel you, Kate. Summer says, I'm in the middle of making chicken and gnocchi. What is everyone doing today? I'm here. I'm doing this for you guys. Okay. So let's get going on this one, because this one is going to be the one that I feel is very interesting. Kate Bell says, it's for my kids' field trip. I was pretty livid. They made us all drive down there. Oh, wow. That is crazy. Okay, so I'm going to keep my coffee here. So if I start coughing, I can take a sip of my coffee. I got Halls here. I brought myself down some cough medicine. I got this thing covered. Hopefully we don't have to use all that stuff, but we'll try them one by one. Should have refused. It sounds good. Summer says, I'm in the middle of, chicken and gnocchi. Sounds really good. I'm hungry. I think I will order something for dinner today because I don't feel like cooking after this. Okay, here we go. This is the order. Let me get my mic back over here. Oh, sorry, earbud wearers. I'm sorry. I'd moved out of the way when I got up. So, okay. Order on defendants' motions to suppress the ATT, the Google, the USB, the Apple, and the Amazon. Defendant is charged with 1 count of burglary. Okay, we know all this. This has been basically what they've put on every one of the orders. But there's parts that are new, so we will read it. As part of law enforcement's investigation, the FBI issued federal grand jury subpoenas to Apple, Amazon, just to Apple and Amazon to obtain information from accounts linked to to the defendant. Okay. I got to get back on track here. The FBI provided responsive information to detectives from the Moscow Police Department who requested and received search warrants for the Apple and Amazon accounts. In addition, detectives sought and obtained search warrants for the defendant's Google accounts, a USB drive containing the defendant's cell phone data, and for information held by the defendant's cellular carrier AT&T. Don't forget, they had his phone number because of previous stops that police made on him prior to the stabbings. Before the court are defendants' motions to suppress the information obtained through the subpoenas and the AT&T, Google, Apple, and USB search warrants. The defendant argues the FBI's issuance of the subpoenas constituted a warrantless search that violated his privacy interests under both the Fourth Amendment and Article 117 of the Idaho Constitution. He further argues that the search warrants fail to command a search and or lack particularity. I'm just going through this to see if there's any little tidbits in the bottom part. If you guys want to read it to yourselves. Okay, so the court incorporates herein its rulings denying both motions. Consequently, this order only addresses the arguments still at issue. Okay. The state's responds that defendant relinquished any privacy interest he had in the Amazon and Apple materials and further contends the remaining warrants are proper and sufficiently particular. Listen, the Olive Garden says we're family, and we are, so come on down. Oh. Okay, a suppression hearing on the portion of the defendant's motion at issue in this order was held on January 24th. That's the one that we did hear. We didn't hear anything from the 23rd. It was only on the 24th we were able to stream it, right? During which the court received testimony from Detective Corporal Brett Payne and Detective Lawrence Maury, both from the Moscow Police Department. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because, 1, the defendant relinquished any privacy interest he had in the records subpoenaed from Amazon and Apple pursuant to the third-party doctrine, and the remaining search warrants are valid. Standard. The standard of review of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. A court's ruling on a motion to suppress evidence combines the issue of law and fact, and the trial court's factual findings will not be overturned unless they are clearly erroneous. When a decision on a motion to suppress is challenged, the application of constitutional principles to the facts found will be freely reviewed. Findings of fact. On November 13th, an officer from the Moscow... Okay, we're not going to go through this all again. The investigation ensued was... This is all in the other ones too. The investigation that ensued was a multi-agency. Okay, so Moscow Police, Idaho State, and FBI, among others. For purpose of the investigation, a command team consisted of several investigators from each of these agencies was set up at the Moscow Police headquarters. The command team included, among others, Detective Brett Payne, Detective Lawrence Maury of the Moscow Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were co-located on the second floor of the Moscow Police Department. The command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. Pertinent information was transmitted into working probable cause affidavit. So this was fluid. This was an ongoing probable cause affidavit. As they got more information, they just added it into the affidavit. So, partial affidavit was already there. They just kept adding things to it as it became available. So pertinent information was transmitted into the working probable affidavit that could be and was incorporated by law enforcement into their various search warrant affidavits. All investigators had access to the search warrant affidavits issued during the investigation. Okay, let's just scan through this to see if there's anything in here that we haven't seen. Okay, these are just giving the dates and everything every time an objection or a motion was filed regarding these. Okay, among the initial search warrants sought in the investigation were 2 at AT&T, the cellular carrier, for a phone number that law enforcement had linked to the defendant. Detective Payne applied for and received both warrants on December 23rd, 2022. As Detective Payne was not an expert in cell phone data, he relied heavily upon Agent Balance, who is a member of the FBI's CAS team, right? Cellular Analyst Survey Team, which they quote as CAST, and specializes in record analysis. Agent Balance aided Detective Payne in both drafting the search warrant affidavits for the AT&T warrants and analyzing the returned information. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for the defendant's arrest. The arrest was effected on December 30th, 2022 at his parents' home in Pennsylvania. At that time, law enforcement seized defendant's cell phone pursuant to a search warrant for the home. To preserve the phone's data, the FBI copied the contents of the cellular phone onto a USB drive, but did not review the contents. Law enforcement also had a warrant to search the defendant's vehicle, which was located in the garage of the parents' home. During the search of the vehicle, a receipt for an Apple iPad was found. Following the defendant's arrest, the FBI obtained and served 2 federal grand jury subpoenas, one to Apple and one to Amazon. In addition, Detective Payne and or Mowry obtained search warrants for records from Google, Apple, Amazon, and for the contents of the USB drive. Okay, so the first AT&T warrant. First AT&T warrant, Detective Payne applied for and sought 9 categories of records associated with the defendant's cell phone. 1, customer subscriber information, device purchase information, associated email addresses, call detail records, cell site information, cell site locations, location information for the cell phone, and text and MMS messages, and cloud data. The objection. The first AT&T objection. Each of these categories was narrowed by a detailed description of the specific information sought. The information requested was temporarily limited to a 48-hour period from November 12th, 2022 at 12 a.m. PST through November 14th at 12 a.m. PST. In his accompanying search warrant affidavit, Detective Payne set forth in detail the circumstances of the crime and the scope and results of the investigation as of that date. That's important. Including evidence linking defendant to the suspect vehicle seen on surveillance videos around the time of the murders. Detective Payne indicated how each of the categories of information sought would aid the investigation, including in determining whether the phone's activity was consistent with the suspect's vehicle route of travel as seen on the surveillance videos, whether the phone was in the vicinity of the murders during or prior to its occurrence as part of planning the crime, and why defendant's phone was not reporting to the network during the estimated time the crime occurred. Based on Detective Payne's search warrant affidavit, the magistrate issued a search warrant for the records sought herein. The warrant stated in relevant part, Brett Payne, having given me proof upon oath this day showing probable cause, establishing grounds for issuing a warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crime of homicide at 1122 King Road in Moscow, Idaho, is on the AT&T account associated with the phone number. They give Brian's phone number between November 12th at 12 a.m. PST to November 14th at 12 a.m. PST. S2 to first AT&T objection, first AT&T warrant. The warrant then set forth each of the categories of information defined by Detective Payne in his search warrant affidavit. It was served by Detective Mowry upon AT&T via email. As was Detective Mowry's practice, he did not include Detective Payne's search warrant affidavit with the warrant when serving it. AT&T emailed a return of the requested information back to Detective Mowry later that day. The return information was immediately turned over to Agent Balance for review and analysis. In reviewing the information, Agent Balance had access to and knowledge of Detective Payne's search warrant affidavit supporting the first AT&T warrant. So AT&T pen trap and trace warrant. Within hours of receiving the return on the first AT&T warrant, Detective Payne applied for a second warrant to AT&T, this time to obtain records associated with defendant's cell phone number for the prior 6 months, as well as for the installation of a pen, register, and trap and trace device for the number, which means anything that he could be using that phone for, that would all be sent to them. So this was before his arrest. The records sought were call detail records with cell sites for all voice, SMS, and data connections. Okay, pen register captures the outgoing phone numbers, email addresses, and other dialing or routing information transmitted by a cell phone. Trap and trace devices capture similar information that is received by the cell phone company, like incoming. So incoming, outgoing. The records sought were call detail records with cell sites for all voice, SMS, and data connection. These records were further defined to include subscriber account information, device identifying information, usage and location information to include cell site positions information, addresses of cell towers used by the device, and subscriber identity information for customers who contact or are contacted by the device. Again, Detective Payne's search warrant affidavit set forth in great detail the circumstances of the crime and the scope and results of the investigation as of that date, including an analysis of the data received from the first AT&T warrant. This information, according to Detective Payne, showed that the estimated location for the defendant's cell phone during the 48 hours before and after the homicides were consistent with the movement of the suspect vehicle seen in various surveillance video. He stated, "Based on my training and experience and the facts of the investigation thus far, I believe that Kohberger, the user of the 8458 phone, was likely the driver of the white Elantra that is observed departing Pullman, Washington, and that this vehicle is likely suspect vehicle 1. Additionally, the route of travel of the 8458 phone during the early morning hours of November 13, 2022, and the lack of the 8458 phone reporting to AT&T between 2:47 a.m. and 4:48 a.m. is consistent with Kohberger attempting to conceal his location during the quadruple homicide that occurred at the King Road residence. As a result, I am seeking historical CSLI from June 23, 2022 to current, prospective location information, and a pen register trap trace on the 8458 phone to aid in efforts to determine if Kohberger stalked any of the victims in this case prior to the offense, conducted surveillance on the King Road residence, is in contact with any of the victims' associates before or after the alleged offense, any locations that may contain evidence of the murders that occurred on November 13, 2022, the location of the white Elantra registered to Kohberger, as well as the location of Kohberger." Whew, that was a lot. 30 more pages to go. A search warrant for information requested by Detective Payne was issued by the magistrate later the same day. The warrant stated in relevant part, Brett Payne, having given me proof upon oath this day showing probable cause, established grounds for issuing a search warrant and probable cause to believe there are records related to the crime of homicide at 1122 King Road in Moscow, Idaho, and are currently under the control of AT&T for historic call detail records for the phone number, Bryan's phone number, with cell sites for all voice, SMS, and data connections between June 23rd to present. The warrant then set forth each of the categories of data outlined by Detective Payne in his search warrant affidavit. In addition, the warrant authorized investigators to install and use a pen register, trap and trace device, and cell site simulator in accordance with IC 186719. Once issued, Detective Payne sent the pen trap warrant to the FBI for service, since the FBI hosted the pen register portion of the warrant. Agent Balance then served the warrant on AT&T on behalf of the Moscow Police Department. Exhibit B to pen trap reply. Detective Payne's search warrant affidavit supporting the pen trap warrant was not served with the warrant. However, the return was provided to Agent Balance, who had access to the search warrant affidavit in reviewing the return. Google warrants. Detective Mowry applied for and was issued 3 different warrants to Google between January 3rd and February 4th, 2023. So this is just after his arrest. Each of the 3 warrants began with the following language: Lawrence Murray, having given me proof upon oath this day, showing probable cause, establishing grounds for issuing a search warrant, and there is probable cause to believe that the property referred to and sought in or upon said premises consists of information related to the investigation into the crimes of homicide at 1122 King Road, Moscow, Idaho, on the Google account of Bryan C. Kohberger. So what they did is they just would change this last part here when issuing warrants, because all of this is going to be the same anyway. Each warrant requested information in connection with email accounts, phone numbers, and international mobile equipment identifier. Numbers that the investigation had revealed were associated with the defendant. The Google warrant issued January 3rd, Google Warrant 1, requested business records and subscriber information in connection with Bryan Christopher 1994 at gmail.com, plus 2 phone numbers and an IMEI number. The Google warrant issued January 24th, 2024, Google Warrant 2, requested business records and subscriber information in connection with YEWSIRNEIGHM. That means something. You, Sir Niam. You, sir, I forget what they said this was. They told me what it was, this name. Anybody remember what they said this name meant? I know it's you, sir, Naum, something. I don't know, but it's weird. It means something, and when I heard it, now I forget. I should have wrote it down. But there is a hidden meaning behind this. It's you, sir, Nightum? I don't know. Anyway, the Google warrant issue February 20. There's you guys can try and figure that out. Let me know if you figure it out. The Google warrant, I know I've heard it before, but I forget what it was. Anyway, it's masked. It means something. There's a hidden meaning there. The Google warrant issue February 24th, Google warrant 3, requested data in connection with all Gmail accounts linked by recovery email, cookie, Android ID, creation IP, or phone number associated with all the accounts linked in Google Warrants 1 and 2, as well as for BK5781@dsales.edu. So they had, like, when you register your Amazon accounts and stuff like that, you got to use an email, right? So these are different emails, possibly even different phone numbers that he used for different accounts. Each of the 3 warrants were temporarily limited to January 1st, 2021 through December 30th, 2023. Why for 2 years? In addition, all 3 warrants listed the following 16 specific items to seize: Google account subscriber information, Google account recent activity logs and connected devices, Google email messages, Gmail including drafts and those in the trash, Google Pay, account information and transactions, calendar and calendar events, contacts, people, contact, and files, photos, videos, and albums associated with metadata, the drive, documents, spreadsheets, presentation, and files associated with metadata, keep, tiles, and the notes, hangouts and chats, messages including attachments such as photos, location history, and deletion records, my activity, which includes searches and browsing history, including activity from web and app activity, Google Assistant, and Google Home, Google Voice, so Google Voice information, including Google Voice Basics, subscriber information, call logs, forwarding number, text messages, and voicemails. YouTube, registration email, channel ID, display name, IP logs, and account registration information. Android, record for Android devices to include subscriber information, other associated accounts, cellular carrier information, and device hardware information. Google Play purchases made and Google Play applications downloaded. Wow. So these warrants were each supported by search warrant affidavits executed by Detective Mowry. In these affidavits, Detective Mowry set forth a statement describing in detail the scope and results of the investigation to date. To date. Okay, so this is fluid. This is still, even till today, it's still fluid. How the accounts and phone numbers identified in each warrant were discovered and how they were connected to the defendant. He also included a detailed explanation as to how Google works and why each of the 16 items listed in the warrants could be relevant to the investigation. Upon receiving each Google warrant, Detective Mowry served it on Google electronically through its law enforcement portal. As was his practice, Detective Mowry did not serve his search warrant affidavit in addition to each warrant. The return for each Google warrant were submitted to law enforcement as a digital file available through Google's law enforcement portal. Detective Payne downloaded each return upon receipt, after which he prepared a receipt and inventory of warrant. Detective Mowry then reviewed the downloaded material to ensure it contained information for the correct accounts identified in the warrants before disseminating the returns to other investigators in the command team to process. Each member of the team had access to the search warrant affidavits supporting the respective warrant. Thus, in processing the returns of the 3 Google warrants, the reviewing investigator was able to refer to the particular search warrant affidavit. Okay, so the USB search warrant. After the content of defendant's cell phone was copied onto the USB drive but not reviewed by the FBI, the USB was sent to Detective Mowry, who stored it in the forensics lab at the Moscow Police Department. Detective Mowry then applied for a warrant to search the contents of the USB. In his search warrant affidavit, Detective Mowry set forth in detail the circumstances of the crime, the investigation, probable cause, A warrant was issued and stated, Lawrence Mowry, having given me proof upon oath this day showing probable cause, establishing grounds for issuing a warrant, and probable cause to believe the property consisting of a Seagate 2 terabyte external USB drive with serial number, they get the serial number, for evidence regarding the investigation into the crimes of homicide of Madison Logan, Kaylee, Zana, and Ethan at the King Road address in Moscow. So he wanted data relating to or containing information indicating, suggesting, or related to violence, a fight, a motive, hostility for any of the same, to include without limitation ledgers, papers, lists, books, notes, letters, calendars, diaries, tapes, photographs, audio, videos, or other media or similar documents or items, computer and communication devices capable of storing electronic data, other electronic storage devices and media, and access to contents of all of the above. Record of communications, written text communications, including emails, SMS, MMS, messages, and other communications, including but not limited to third-party applications such as Kik, WhatsApp, Facebook, and Instagram, contacts stored, and location information. Location information stored in any cloud account associated with the phone if said account credentials can be obtained from the forensic image of the phone. Internet history, bookmarks, and or associated cloud accounts, written and audio recorded notes, or any cloud account associated with this device, indica of residency in ownership or possession of the premises, and any of the items above items located in or upon the following described premises located in Utah County, state of Idaho. The Moscow Police Department is located, and they give the address. Forensic labs on the 2nd floor. You are therefore commanded to search the above described premises for the property described above to seize it is found and bring it promptly before the court above named. So they're just saying what they're doing here. Apple, they did the same thing with Apple. Now, there is some different things here, okay? They got some different email addresses. So they subpoenaed The FBI served a grand general. Oh my gosh. A grand jury subpoena upon Apple Inc. on or about January 12th, 2023. Apple responded on January 27, 2023, providing subscriber information for 2 Apple accounts associated with the defendant. This is a new address. B. Kohberger at Spartan Northampton.edu, which Apple indicated was active, and Wi-Fi are my owns. Wi-Fi are my army owns. Huh. So that's another email address. I wonder what that means to him. Wi-Fi army owns at yahoo.com, which Apple indicated was locked. Ooh. And the defense filed an objection to both accounts were created on October 7, 2016. The subscriber information provided by Apple also revealed the active account, which is this first one, B. Kohberger at Spartan Northampton.edu. That account was active and had last been accessed on December 20th, 2022, just days before the defendant's arrest. On or about April 6, 2023, the FBI issued a preservation request to Apple for these 2 accounts. Okay, so again, they're just explaining again what they did, that the same as in the last warrant, why they wanted this information. They also shared the information from the Apple subpoenas with Detective Payne and Mowry. Like I said, if you want to read this yourself, you can pause it and go ahead. The defense objected to this. The search warrant affidavit discussed in detail the circumstances of the crime, results of the investigation to date, and why defendant was arrested and charged. Detective Payne also conveyed that the defendant was seeking an advanced degree in criminology and had studied cloud-based forensics prior to the crimes. The affidavit discussed how the defendant had attempted to conceal his location during the period immediately before and after the crime was committed. Detective Payne also detailed an explanation about what types of information Apple captures and maintains from the users of Apple accounts, and that he believed the information sought from Apple would provide information concerning Kohberger's plans, thought processes, research, locations, photo, or other pertinent information stored in his Apple account, including his iCloud. So again, here's what they sent for these 2. We've seen this before in the previous warrant, so I'm not going to go through it all again. If you do want to, you can pause it and go through it. The Apple warrant set out 9 categories of information sought by Detective Payne: account identification records, records regarding devices associated, contents of emails associated, the contents of IMs, instant messages associated, the content of stored iCloud files, activity connections and transactional logs for the accounts, location where the accounts were accessed, records pertaining to the types of service used, information necessary to decrypt any data. Other than its reference to the data of the crime being investigated, the Apple warrant was not temporarily limited. It was also served electronically by the Apple's port for law enforcement. They got it. They got the return about a week later. Okay, so Amazon subpoena and search warrant. Okay, so at some point in the investigation, the FBI located an Amazon account associated with the defendant. It served a federal grand jury subpoena upon Amazon seeking order history records. Amazon responded by providing the FBI with the defendant's Amazon subscription information and purchase history from January 1st, 2022 to December 13th, 2022. After receiving this information, Detective Mowry applied for and received a search warrant for records retained by Amazon for the defendant's account regarding customer click activity, details of items added or deleted from his cart, and all suggestions made to the account. Advertising data, device identification information, and linked accounts with date range of March 20th through 30th and November 1st, 2022 through December 6th. So, conclusions. Having already dispensed with the affidavit, the defendant's arguments regarding whether the warrants at issue in the four suppression motions addressed herein were invalid under Frank's and or as a result of law enforcement's IGG investigation, the remaining issues are as follows. Whether the grand jury subpoenas violated the defendant's privacy interests in his Apple and Amazon accounts under both the Fourth Amendment and Article 1.7 of the Idaho Constitution. 2, whether the AT&T, Google, USB, and Apple search warrants were sufficiently particular, and 3, whether the Google, USB, and Apple search warrants properly command a search. The court finds suppression is not warranted on any of these issues. The defendant does not have a privacy interest in the subpoenaed records protected by a Fourth Amendment. So the Fourth Amendment, it goes through the Fourth Amendment. It says, however, a person challenging a search has the burden of showing that he or she has a legitimate expectation of privacy. The judge said the subpoenas do not violate the defendant's Fourth Amendment rights. If you want to read exactly what he says here and how he applies it to the law, you can read it here. He goes into different cases that have already been decided that he is citing. Like I said, again, you can pause, you can read through this if you want to see how he's already given his decision on it, but these are the cases that he cited that helped him come to his conclusion. So we'll scroll through this until we get to the next one. The Amazon records consisted of his purchase history and associated account information for 1 year. The Apple records were even more limited, consisting of account subscriber information and the date that the account was open. While both Amazon and Apple are certainly capable of obtaining far more information by its users, the information specifically sought and obtained here through the subpoenas was extremely limited. Then they're going on to talk about how other cases were, whatever. Okay, so likewise generated by the defense affirmative act in visiting the Amazon website, shopping for items, placing them in his cart, and arranging for delivery and payment. Had he been shopping in a physical store, there's no question that under Miller, the security video footage of him shopping and transaction records could be obtained without implicating a Fourth Amendment. So he's giving all these reasons why what they did isn't illegal. Okay, so the next one, number 2, is the Idaho Constitution affords no greater protection than the Fourth Amendment. So at times, the Idaho's appellate courts have extended protections under Art 117 of the Idaho Constitution beyond that provided by the Fourth Amendment. This greater protection has been based on an analysis of 3 factors: the uniqueness of our state, the Constitution, and our long-standing jurisprudence. Okay, with regard to the third-party doctrine, Idaho's appellate courts have determined, with one exception, that protection under Article 117 of the Idaho Constitution is coextensive with the Fourth Amendment. That exception arose in State v. Thompson, where the Idaho Supreme Court rejected the majority reasoning in Smith and held that the use of a pen register constituted a search. And recognizing a legitimate and reasonable expectation of privacy in the phone numbers that are dialed. The court, without any additional explanation or analysis, adopted and exerted both the reasonings of Justices Stewart and Marshall in their dissenting opinions. Okay, so this is his reasoning. He's going back and going over these cases, where you should expect privacy, where you shouldn't, etc. And he's denied all these too, so he denied the motion to suppress the pen trap. The warrants are sufficiently particular. Hang on a sec, you guys. Okay. So the defense was saying that the warrants weren't sufficiently particular. The Fourth Amendment of the United States Constitution, in Article 1, Section 17 of the Idaho Constitution, prohibit the issuance of a warrant unless it particularly describes the place to be searched and the person or things to be seized. The purpose of this guarantee is to safeguard the privacy of citizens and to prevent such rummaging. The Fourth Amendment requires a particular description of things to be seized. So what they're saying here is that it was too vague, and whether they really had probable cause to be able to do this, etc. This is the explanation that the judge is going to give, that says why what they did was lawful and just. They're going to go over a bunch of different cases and whatnot here. So defendant's challenges to the warrants at issue regard searches for digital data associated with the defendant's cell phone and Google and Apple accounts. While the particularly requirement is not unusually difficult to apply to a physical world, courts recognize it is more challenging to apply to the digital world. As observed in the United States Supreme Court, cell phones with their immense storage capacities akin to powerful mini computers have become repositories of nearly every aspect of a person's life. Vigilance in enforcing the probable cause and particularly requirement is essential to the protection of the vital privacy interests inherent in virtually every modern cell phone and to the achievement of the meaningful constraints compelled in Riley. So electronic data can be hidden in multiple formats and placed in cell phone or on computer. Consequently, it can be difficult for law enforcement to specify in advance the sections of the device that need to be searched. So the defendant's challenge to the search warrants at issue focus on the latter. Okay, so this is why they maybe were so vague in some of the warrants, but it does say this is what they're searching for. And we're going to search this computer no matter what part of the computer we got to search. We just want to leave it wide open because this is what we're looking for. And because it can be stored in so many different places, like you got additional drives you can get on your computer now and stuff like that. You got the cloud, you got this, you got that. They needed that open-ended so they could search the whole computer for what they were looking for. And they did detail what they were looking for. So anyway, like I said, if you do want to read through all these, everything that's been cited, you can. I'm just basically interested in any new information and what the judge decided. So, in opposing the defendant's suppression motion, the state relied on this pre-printed form language as limiting what it acknowledged to be otherwise sweeping authorization. The court noted that while such a broad language may be permissible where the warrant contains a residual clause or other limiting language containing the search to evidence of a specific crime, pre-printed language provided no such limit. So they're going to state other cases where this was decided before. And it says here, because law enforcement cannot know in advance how a suspect may label or code files containing evidence of criminal activity, by necessity, government efforts to locate particular files will require examining many other files to exclude the possibility that the sought-after data are concealed there. And that's what I was just explaining. They don't know where he could have had files on each and every one of these victims and hidden in a file that said homework. You know what I mean? So that's why they made it so broad that they could search every file and everything on that computer and only take the information that from that computer or device that they had listed in the warrant. However, as the defendant notes, the inclusion of a residual clause or other limiting language is not a green light for law enforcement to search in electronic files where evidence of the crime is unlikely to be. Well, they don't know that unless it's there, especially somebody who has been studying law as long as he has. They know how to hide things, so it's not easily seen. Like, say, and this is just a hypothetical, say he did have files on each of these victims. He could have hidden that as places to order car parts, a file that says that. Well, car parts isn't on their search warrant, so they wouldn't be able to search that file, right? So in that file, he could have hidden information. So that's why they do it the way that they do it, and that's why Anne is opposing it. And because he is, versed in law, he studied cloud storage and forensic storage. He would know how to hide things within other files. So, and that's what they're saying here. For example, if there is probable cause to believe that evidence of a crime will be found in text messages, but not in photos, videos, or any other applications on a particular device, then the warrant allowing officers to access all the data in the device would violate the requirement. But they asked for everything. They asked for a lot of these things, right? They know they're sunk, and they're just at this point, you guys. Ann Taylor is just trying to cover every aspect that nothing can come back for ineffective counsel. Okay, let's see. Let's go. So again, this is basically what I just said to you. This is what it is describing. Like I said, if you do want to go through these, then you can pause. We're almost through it, you guys. Okay, so regarding the AT&T warrants, okay, so the court finds that the AT&T warrants, even without supplementation by their respective supporting affidavits, satisfy the particularity requirement. So the judge says, look, they put enough information there, you're beat. I'm denying your motion. He says, while the warrants covered a broad array of digital information held by AT&T, they did not authorize a fishing expedition for any and all data as was the case in Wilson. So again, they said what their limits were. They said what they were going into the phones looking for. Now, just say hypothetically that they went into Bryan Kohberger's phone and they found evidence of another crime. Evidence of him going, okay, let's just put it this way. This is all hypothetical, you guys. Say they went into Bryan's phone. They're searching for what they put in the warrant that they said they were searching for. They go into his phone and they find a video of him, getting out of his car and going into the store and saying, watch this. Watch how easy it is to steal from this store. He goes in, he steals something, and he goes out, gets in his car, and he leaves, and he videotapes it all, right? And that video is on the phone. They can't use that against him because that is not part of the investigation that they were looking into or the information that they were looking for. So they would not be able to hold that against him and charge him with that. Okay? So that's what I'm saying. So that's what this basically says. Look, this is what we did. We put in our warrants. We discussed what we wanted from these warrants. It's going to have to be a larger blanket. We are not going on a fishing expedition, but we do have to fish inside some of these files to see if he has hidden stuff related to this investigation in those files. Now, if we find something else in those files that have nothing to do with this investigation that we're doing, but are criminal in nature, there's nothing we can do about it because you don't have a warrant to get that stuff. It's like you didn't see it. You know what I mean? Now, if it's something like another red drum, believe me, they would use it. But I mean, you know what I mean. Say there was photos. They were looking for photos of the victims, of any maybe him snapping pictures of the house as he drove by, if he was stalking the 1122 King Road address, stuff like that. If there was pictures of that home or the victims or anything like that, if he had those pictures, those they would be able to use. But if he had pictures of, a picture taken through a window of some other woman getting undressed, they can't use it. You know what I mean? Because the warrant is specific to what they're looking for. They just want to be able to search the whole thing in case the files they're looking for or things that they're looking for are hidden within other files that are labeled something different, like car parts, right? Okay, so Agent Balance both aided Detective Payne in drafting the AT&T search warrants and had access to them during his analysis. This is sufficient for the search warrant affidavits to accompany. In his search warrant affidavits, Payne discussed at length the circumstances of the crime, the results of the investigation, and then why the defendant was a suspect. He included detailed explanation about what types of information a cellular carrier retains, specifically regarding the location of a cellular device, and why that information could provide valuable evidence in the investigation of the case. Thus, to the extent the AT&T warrants were lacking in specificities, the search warrant affidavits cured it. Suppression is not warranted. So now he goes through for all of these, you guys. And like I said, we are on page 25. There's 11 more pages. I'm going to skim through them briefly because the next, like the Apple warrant is going to basically tell you exactly what we just gone over. They want to search the Apple accounts. They want to search the iCloud. We'll read it right here, but the rest of it is going to be just a replay of what we just went through on the other search warrant. Okay, so with regard to the Apple warrant, defendant asserts it casts, this is what the defendant is asserting, that it casts too broad of a net, effectively allowing the search and seizure of all data from the two accounts. The state responds that, particularly when considered with Detective Payne's supporting search warrant affidavit, the Apple warrant imposed subject matter and temporal restrictions that were as narrow as could be, reasonably expected, given the nature of the investigation and the object of the search, electronic records. The court finds, standing alone, the Apple warrant satisfies the particularity requirement. To this end, the court finds two cases to be instructive. The first is, and he's going to go through other cases that have already been decided, and he's going to base a lot of his opinion on. To this end, the court finds two cases to be instructive. Okay, so this is what he's going by. The warrant identified the accounts to be searched by the phone number and Apple ID. It also described the data to be disclosed by Apple, the evidence the government could search for. So this is in the United States versus Plea. This is what the court decided. The Ninth Circuit found the warrant was not a general warrant because it did not allow the executing officer to rummage through Paleo's iCloud account without discretion. Okay, so here's the second one that he used to decide. And like I said, you can read through all of this if you wish. But he's just citing other cases. Okay, so in his search warrant affidavit, Detective Payne discussed at length the circumstances of the crime, the result of the investigation to date, and why the defendant was a suspect, just like the last warrant, right? He included a detailed explanation about what types of information Apple captures and maintains from users of Apple accounts and why he believed the information sought in the Apple warrant would provide information concerning Kohberger's plans, thought process, research, locations, photos, or other pertinent information stored on his Apple account, including his iCloud account. He also identified a temporal range for the search of October 7th, 2016, dates accounts were created, to December 30th, 2022, the date that Kohberger was arrested. Thus, to the extent the Apple warrant was lacking in specificities, anyway, the search warrant affidavit cured it. Okay, suppression is not warranted. So again, nope, you're not getting it suppressed. Now it's going to go on to say the same thing with Google. Like I said, I'm going to scroll through this. This is basically going to repeat what we just read. Okay. That they had warrants, they had more specifics. They didn't include it with the warrant because it wasn't needed via the portal for Google, blah, 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 blah. But and the defense had the particulars of what they were looking for and everything else. And the backing for getting that information, they have all that. They don't have to include it with the warrant because Google doesn't require it. So they just sent, this is why we need the warrant. This is the information we have. We're legally entitled to it. Give it to us, right? They had probable cause. So that's how they got it. And this is just going to be the same repetitive stuff that Anne says. There's not enough information. Not enough information was given. They left it too broad. They could search everything. That's not right. What he is doing. I want it suppressed, blah, blah, blah. So I will scroll through this slowly so you guys can pause it and read it. Oops. Okay, so this is a little different. Let me just take a drink of my coffee here. I seen this. This is, like I said, this is the first time I'm going through these two. So here, Detective Mowry's search warrant affidavits in support of the Google warrants were far from bare bones. They provided an extensive explanation as to how the defendant was connected to the homicides, how each email account, phone number, and IMEI at issue in the warrants was discovered, how they were linked to the defendant, and why Google data associated therewith could produce evidence of the homicide. In the affidavit for Google Warrant 1, Detective Mowry discussed how the investigation led to the discovery of the two phone numbers. That's interesting. Then he outlined why his training experience he believed the various Google records for each account could be determining time periods, devices associated. Okay. So then they go into the second warrant. He explains that the information gotten from the first warrant gave them more information as to what else could be on that account relating to this crime. Like I said, I'm just scrolling through this, you guys, so you can pause it later and go through it. But it's basically, they're just saying the same things over and over, why it was legal what they did, why they needed this extensive access, etc. I'm just really being quiet here as I scroll. So if I do see anything that seems to pop out to me, I will stop and go over it. Okay, so this is what the judge is saying. To the extent the Google warrants are not sufficiently particular standing alone, the search warrant affidavits cure any deficiencies. Each of the Google warrants referenced its respective search warrant affidavit. So even though even though the affidavits weren't attached to the warrant, they don't have to do that. They have a form that they fill out with Google or Amazon or whatever for law enforcement. This is what we got. We're entitled to it. We got a warrant for it. They don't have to include all that. All they got to do is say, we've got the warrant. Show them the warrant. They don't have to include all the affidavits and everything else that goes with that warrant. Okay, so each of the Google warrants referenced its respective search warrant affidavit. Example, Maori having given me proof upon oath this day showing probable cause. Additionally, the search team processing the returns had access to the search warrant affidavits. Thus, the affidavits were incorporated into the Google warrants. In these affidavits, Detective Maori set forth a statement describing in detail the scope and results of the investigation to date, how the accounts and phone numbers identified in each warrant were discovered, and how they were connected to the defendant. He also included a detailed explanation as to how Google works and why each of the 16 items listed in the warrants could be relevant to the investigation. When considered with the Google warrants, there can be no dispute that particularity is met. Suppression, therefore, not warranted. And they're going to go through with the USB warrant. That's when they first arrested him. They confiscated his phone. They plugged in a USB and they copied his phone to the USB. This is going to be basically the same thing. The warrant, okay, so they specified in the warrant things that they wanted, but it wasn't limited to certain things. But some of it was the data compilation category is limited to the information indicating, suggesting, or related to violence, a fight, or mode of hostility for any of the same. So those remaining categories, he argues, are necessarily included in the data category, yet they are not similarly limited, effectively allowing a search of all the contents of the cell phone. So he goes through this again. Like I said, if you do want to read through this, the USB warrant not as limitless as the defendant claims. First, while it is not temporarily limited, the object of the search was specifically to evidence regarding the investigation into the crimes of homicide of Madison, Kaylee, Zena, and Ethan at 1122 King Road. So they used a court case, whatever, versus Wilson, and they're saying that that doesn't apply to their warrant because of deficiencies. Okay, so like I said, it's going to be more of the same, saying that they weren't, they didn't state certain things, they left it too broad. They're saying that the USB warrant alone is deficient. But again, this is what the judge is saying. Again, to the extent the USB warrant alone is deficient, the search warrant affidavit supporting it can supplement, particularly given that it was referenced within the USB warrant and available to members of the search team processing the information. Consequently, the court finds particularity is met and suppression is not warranted. So, which means even though it wasn't on it was in the affidavit, and they wanted this also, you know what I mean? So it kind of covers everything. So the USB warrant alone is deficient. They're saying that the supplement of the affidavit is more than enough. Sorry. Okay, so the defendants were on page 33, you guys. So any deficiency in the warrant's command to search is not a basis for suppression. The defendant's final challenge to the warrants is that they do not properly command a search of the information seized. The court does not find the warrants are deficient in this regard, and even if they are, it is not a basis for suppression. A warrant must identify the property to be searched through the name or description, be directed to an authorized peace officer, and command the officer to search within a specific period of time. As observed by the Idaho Court of Appeals, search warrants are not deeds or tax notices. They are not subject to technical drafting requirements. They should be interpreted as a common sense and realistic fashion. Ooh. Defendant's challenge is based on an over-technical reading of the warrants. The Apple warrant identifies the two Apple accounts to be searched, and the specific information from those accounts to be seized, all of which are located at Apple Inc.'s premises. The command then states you are therefore commanded to search the above described premises for the property described above, to seize it if found, and bring it promptly before the court named above. Likewise, the Google warrants identify the accounts to be searched, and the same thing. And he's going to go over all of this. So like I said, if you want to read it again, he's basically already said it above. Most importantly, any deficiencies in the commands to search are not of constitutional dimension. First, it is well settled in the federal arena that a violation of Rule 41 alone does not require suppression of evidence if the search otherwise conforms to constitutional standards. And he goes on to cite this case. Okay, with regard specifically to erroneous descriptions of the place to be searched, Idaho looks to whether the place is described with sufficient particularity as to enable the executing officer to locate and identify the premises with reasonable effort, and whether there is any reasonable probability that another premise might be mistakenly searched. Defendant has not shown either prejudice or deliberate disregard of ICR 41D. Further, as noted, the places to be searched are reasonably described as to avoid any chance that a mistaken premises might be searched instead. Consequently, suppression is not warranted due to alleged problems with the search commands. Based on the foregoing, the court denies the following. Defendant's motion to suppress the AT&T first warrant. Defendant's motion to suppress the pen trap and trace device. The defendant's motion to suppress the Apple account federal grand jury subpoena and search warrant dated August 1st. Defendant's motion to suppress Amazon account federal grand jury subpoena and search warrant dated April 26, 2023 and May 8th. Defendant's motion to suppress Google warrants. Defendant's motion to suppress Moscow Police Forensic Lab warranty dated January 9th. So that is that, you guys. Let me stop sharing. Okay, so everything that we heard on the 24th, that part, we also heard part of some of the arguments that the defense made in the 23rd motions hearing. It was also talked about in these documents that we just went over. The only one we didn't get to, you guys, we've been here 4 hours. We can go over the IGG one at a later date. I just can't do it today. I've been here 4 hours. So basically everything, all the motions to suppress have been denied. They're at the end of their rope. They're hanging on by one tiny little cotton thread. I don't know what else she's going to bring up to argue. It seems like this was her last ditch attempt to have things suppressed. I'm not going to be surprised if she does come up with more motions, since none of these stuck. She may have something else up her sleeve. We don't know. But we do know that he's not due back in court for another, month and a half, 2 months. As far as we know, the trial is going to start August 11th. Everything's been denied, you guys. Everything. Even the motion to suppress the IGG, which was already dealt with Judge John Judge, right? They tried it again here. It didn't work. We can go over that. It's 29 pages, but I will not be able to do that today. Maybe we'll do it in a brief tomorrow morning thing or something. But the defense, I don't know. I don't know what they're going to do. I don't know what they're going to try next. I don't know. It seems to me there's not much more they could fight. They know their ship is sinking, but it's not for lack of trying to save the ship. Even if it was, to save the rudder. Nothing has been saved. So let's see what Ann Taylor comes up with next. I think with these orders that she has seen the judge just present and give, I think she's going to be leery. I don't know. But I'm going to wrap it up for now, you guys. Thank you for being here, going over these with me. If you do want to read through the documents, I scrolled through a lot of the information so you guys could see it. It's very repetitive. It has the same outcome. Just because an affidavit wasn't attached to a Google or AT&T or Amazon or whatever warrant doesn't mean that it's invalid, right? They gave enough information to make it valid, and they have affidavits that support it. So we'll see what happens next, you guys. But until then, I'm going to end it like I always do. Thank you for being here. Thank you for your super chats, for your donations. I really appreciate it, you guys. I love the commentary. Some of the things that you guys have even, come out with, comments of your own, gets me thinking too on certain things. But yeah, just like Nana says here, they're running out of motions and they're running out of time. So with that being said, thank you all for being here. I appreciate each and every one of you. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys.